Boom. Hey folks, how's everyone doing? I hope everyone's having a good time. Ah, it's a Monday, which I got to adjust this. There we go. A little bit. Give me one. Close enough. We'll live. So the new camera is not being very helpful. Let me show you what the new camera is doing. Yeah, if you're thinking this is not great, that is correct. It is not. I have no idea why it's doing that, but that is what it's doing. So I did manage to get the old camera working. So we're stuck on that for now. But the new camera doesn't seem to want to work. So we're using the old one, and I don't think anyone's tuning in to see my pretty face. That is just not that's not the draw here. All right, so we have some interesting stuff to cover. I was like, hey, maybe this will be a slow day. Maybe it won't be. Maybe not that much will be going on. So yeah, that is not actually how things went in the slightest. Things have been popping off, as they say. So let's consider our options. We have Chud the Builder. Now, if you don't know who Chud the Builder is a nuisance streamer, which means his whole thing is that he goes into like public spaces and basically pisses people off for a living. And so he goes and pisses people off, and then when they react, he films the reaction. He's like, hey, look at this person, look at how badly they're reacting. Well, no shit, you're acting like a jackass. So that's his thing. We also have Becky Hill and Murdaugh. Murdaugh is suing Becky Hill for lots of things, basically civil rights violations. And that should be interesting. That'll be fun. I wonder why, though, because there isn't. We can talk about that when we get to it. We also have a big development in the Luigi Mangione case. Some evidence in the Luigi Mangione case was thrown out, and people are talking about this as like, oh, great news for Luigi. He's gonna win. He's like, all of this stuff has been, tossed out. It's not really a win. Luigi Mangione got a partial win, but he lost all of the important shit. So because he lost all of the important shit, he is pretty fucked, honestly. So maybe we'll do a poll here. We'll just do a quick poll just for which thing we should talk about first. I also have a what is it? There's also a case in a Canadian case, but I don't know if we'll get to it. And it's kind of a messed up case because this guy forced a woman to eat her own finger. Yeah, you heard that right. And then the court had to deal with the question of, was there sufficient, or was the sentence that was originally imposed sufficient? Because originally he got like 4 years. And which to me is kind of a ridiculous thing, right? To be like, hey, you chopped someone's finger off, and yeah, and a 4-year sentence. I'm like, no, that is wrong. That is terrible. That is the worst. That is, yeah. So All right. So, I'm just looking at the poll here. Poll is very evenly split, with Luigi Mangione having a slight lead. Very slight, but what is it? Yeah. Let's see. Just trying to find a good image here of Mr. Chud. All right. So I see Murdaugh has now pulled ahead. We'll give it another moment here. Also, what is it? I have been spending the day cooking. I have been spending the day, tinkering with my recipe for chicken hearts. I got to remember to sit up straight with this camera because it's not angled the same way. So, I've got a recipe for chicken hearts. I spent the day, or I spent part of the day making that sort of a new, so that I could get like amounts ish, and also just, I did a little bit of tinkering. But the other thing I was experimenting with, and this is kind of a big experiment, was I was making coq au vin, which is, chicken in wine. But it's Mrs. Runkle's favorite food. It's like her all-time favorite food. So when her dad asks her about, hey, it's your birthday, what should I make you for your birthday dinner? She is very likely. I'm going to do something horrific, by the way. We got the red wine. We're adding Coke to it. There we go. So when asked, she, that's what she goes for, but it's her dad's recipe, right? So I'm trying to match it or mimic it or follow it. And what is it? The problem is that this means that the stakes are very high. The stakes are real high because I cannot get it wrong. Where is the tie? Tie was supposed to be there. Tie must have fallen down, and I'll find the tie. Okay. So, yeah, and it's a pain in the ass. I don't know if you've ever made this, I don't know if you've ever made it, but you start out and you are cooking all this stuff, and it's the recipe as it has is make it into one pot, but keep moving stuff out of the pot, which I'm like, why wouldn't I just do multiple pots? But then you have to stick it in the fridge and leave it overnight and then continue cooking it the next day, which is okay, cool. Yeah. And I see some people who are going, why did you put Coke in your red wine? It is actually really good. I know this is something that a lot of people struggle with. They're like, why would you do this? It's actually really tasty. And this is a really good summer drink, believe it or not. Let's see. It is warm in here, so I'm just turning something on here. All right. So if you are sitting out in the backyard in the sun and having a nice evening, red wine and Coke is actually really good. So it is tasty. And the best thing is it's a great way to deal with what do you call it? Really cheap wine, because this stuff actually works really good with some of the there's this cheap blended wine that also comes in a box. If you can get it in a bottle, but you can also get it in a box, and it actually works really good with it. So Yeah. Any specific kind of red wine? I often use this brand Apothic. They're not a sponsor because they're not very good, but the but it works really well, like mixed in. All right, so the poll looks like it is 39% Murdaugh, and then split evenly between. Oh, Chud looks like he's next. Yes, the red kind. So it does cut down on the wine aftertaste. Yes, and yeah. The other thing is I need to start a goal, and I have a bunch of hot sauces left to try. So our first goal is going to be to sample a Maritime Madness sauce, because I've got a whole bunch of those. All right. So let's start off with Murdaugh. So if you don't know who Alex Murdaugh is, he's Richard Alexander Murdaugh. Alex Murdaugh is he was a lawyer, and what ended up happening was he was charged with financial crimes, because basically he was blowing through money faster than he was earning it, and so he was blowing through tremendous amounts of money, stealing it from his firm, stealing it from his clients, stealing it from basically anywhere that money wasn't nailed down. And so then that was being investigated. They were starting to discover that. And then his family got murdered. And he was charged and convicted with murdering his family. But, yeah. I'll give you $20 now to do Mangione right now. I would have taken that deal, except I've already started, so I'm sorry. Now, Murdaugh, his trial was rough. Because, for one thing, notwithstanding that he was a lawyer, the guy was a moron and gave a statement to the police, which was idiotic and, like, whatever. The other thing is that he his case was really, like, his case ended up being a giant disaster. And it was a disaster for two reasons. Reason number one why his case was a disaster is that the state managed to get in a whole bunch of different evidence about his financial crimes that had absolutely nothing to do with whether or not he committed the murders, because they basically just went whole hog on the prejudicial effect, and the court let them do it. Like, the court just was like, you can totally do all the prejudice. That's just fine. And that was like, that was not an issue at all, right? They're just like, okay. And so the appeals court was like, that wasn't cool. But that wasn't the main reason why the case got tossed. The main reason why the case got tossed was the involvement of Becky Hill, Rebecca Hill. And what Becky Hill did was she came in and she had this idea. She had this glorious idea. She was like, you know what? This case is going to be huge. Everybody's going to be watching this case. Everybody's going to be following this. Everybody's going to be, like, all the law tube is going to be covering this. All of the media is going to be covering this. This is super, super big news. And I want a lake house. And you might be saying, Runkle, that's silly. A lake house? Seriously, she wanted a lake house. And so so what she thought was that she was going to write a book, and she was figuring that she was going to sell so many copies of this book, and that everybody was going to buy this. They were going to spend big money on this, and she was going to get all this money, and she was going to be able to get a lake house. So what the allegations were, and the court has basically confirmed this, the allegations were that she came in and basically suggested to jurors that they should rule in a particular way. They suggested to the jurors that they should totally convict because that would be, that would be better. She had the idea that, that things would be better if, if he was convicted, right? So she was like, yes, I want to see this, I want to see a conviction here. And, if I get a conviction, then that will sell more books, and I will get more books, and I will be good to go. I'll get more money. I'll be able to get my, I'll be able to get my lake house. And, to put this into perspective as how big of a deal this is, quite frankly, this is one of those cases that if there wasn't a new trial ordered, I would lose all faith in the judicial system, right? I would just be like, this is insane. Also, I have a non-artist rendering. I have an AI rendering of Becky Hill's imaginary would-be lake house. So this is the imaginary lake house that Becky Hill wanted. Now, the other fun thing about that is that not only did her book suck, because a few people bought the book and were like, man, this book sucks, but also it turned out that she plagiarized parts of it, which is even worse. So not only did the book suck, she didn't even write all of the book. And so what is happening now? Well, Murdaugh's got his new trial, right? And so now he's bringing a lawsuit against Becky Hill. And I see people saying one book wouldn't pay for that. Yeah, you're right. Books actually make surprisingly little money. If you go through a traditional publisher, you will make, most likely on your first book, you will make literal thousands. And you might say, Runkle, thousands, that's great. I didn't say tens of thousands. I said thousands. Just, thousands. Now, when you consider the amount of work that goes into writing a book, coming away from a book, with like a $5,000 deal or whatever, and 5,000 is actually a pretty good, you're doing really good if you get $5,000, for your first book. If you put that into a per hour basis, you are probably making minimum wage. If you look at a lot of, a lot of art, like a lot of authors and so forth, a lot of self-published authors lose money. They make negative money. A lot of, there's a lot of risk, right? A lot of authors, author isn't their job. Author is the thing they tell everybody that they do because it's what they want to do. But they're author who also works at wherever, right? So, it's a big thing, right? You have to actually, in order to make real money as an author, you have to be lucky or good, or, I might do better because I've got like a platform, but I wouldn't bet on it. Like if I wrote a book, and I am working on a book, but I don't know if I'll ever get it finished. But like if I wrote a book and I put it out right now, if everybody in this chat bought a copy of the book, I would not be making huge money, right? There's 1,300 people here. It's just, that's it, right? So that's the realities of it. So anyway, now because of her grand book aspirations, she is getting sued. And so let's cover the lawsuit. I don't know why Monday might not be the best day. I need to think about moving things to Friday, just on like a permanent basis, because it is really quiet. I'm wondering if there's somebody else streaming right now that's, getting attention or whatever. But yeah. All right. 1,300 minus 1 now. Well, shit. Somebody left. All right. So let's have a look here. All right. So Richard Alexander Alex Murdaugh, through his undersigned attorneys, brings this civil rights action against defendant Becky Hill, formerly the clerk of the court for Colleton County, South Carolina, and would respectfully show this court the following. This is a civil rights action pursuant to law against defendant Becky Hill, former clerk of the court for Colleton County, for the deliberate and egregious deprivation of plaintiff's constitutional right to a fair trial before an impartial jury, guaranteed by the 6th and 14th Amendments to the United States Constitution. No right touches more the heart of the fairness in a trial than the right to an impartial jury, citing to Barnes versus Joyner. That right was stolen from Alex Murdaugh by Becky Hill. And the thing is that Alex Murdaugh can show actual damage from that, right? Because he's like, look, I got convicted. I had to do a retrial. Told you to do Mangione first. People are Murdaugh'd out. I mean, I get that, but this is also like people are still coming in. You are missing the point of Chud completely. We'll get to Chud. So, on March 7th, following a 6-week trial in Colleton County, 6-week trial. You guys cannot understand how expensive a 6-week trial is. It's really expensive. Really, really insanely expensive. Murdaugh was convicted of the murders of his wife, Maggie Murdaugh, and his son, Paul Murdaugh. He was sentenced to 2 consecutive life terms. He maintained his innocence then. He maintains his innocence now. Neither Murdaugh nor his counsel knew at the time of trial that Ms. Hill, the elected clerk of the court for Colleton County, the officer of the court charged as the primary caretaker of the jury, had secretly and deliberately inserted herself into the jury's deliberative process for personal financial gain. As the Supreme Court of South Carolina has now held, Ms. Hill placed her fingers on the scales of justice. Acting under color of state law and abusing the power and authority of her elected office, Ms. Hill made repeated improper extrajudicial communications to jurors in which she urged them not to be fooled, confused, thrown off, or convinced by Murdaugh and his defense. In so doing, Ms. Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility, and essentially implored the jurors to find him guilty, the ultimate issue in the case. By the way, one of the interesting things that will result from this is that the jurors might actually be called as witnesses. And so we might actually be in a situation where the jurors get brought in and questioned about this, right? Where the jurors are, and there may or may not be protection for their identities. So their identities might end up getting revealed to the public. Ian, did Ms. Hill get charged? She got charged and pled guilty to perjury for which she received probation, which to my mind is crazy. So, why did he call his son Pawpaw? I don't know. South Carolina. So Ms. Hill's motive was her self-serving desire for personal profit. She wanted to write a book about the most high-profile trial in South Carolina history so she could buy a lake house. Shown here, the lake house that she might have imaginarily bought if she could have bought a lake house. So, and as the South Carolina Supreme Court found, she believed a guilty verdict would be the best way to sell books. She was, in the words of former Chief Justice Toll, attracted by the siren call of celebrity and allowed her desire for the public attention of the moment to overcome her duty of oath to her oath of office. Ms. Hill's improper communications to the jury were deliberate acts repeated across multiple occasions, directed at jurors she was sworn to protect from outside influence by an officer of the court elected by the very people who make up the Colleton County jury pool. Her conduct was, according to the South Carolina Supreme Court, breathtaking, disgraceful, and unprecedented in South Carolina. To put this into perspective, a lot of the case law that they ended up citing in this case was from like the 1970s and earlier. And the reason, and so you get things like, the bailiff going, that wicked man, right? And the reason why it's that wicked man is because it's so fucking old. And the reason why all this case law is so old, so antiquated, so like historical, it's basically period drama, is because this shit doesn't happen often. This is like so rare that somebody is this level of fucking dumb that they end up having a case about this. Like, it's just absolutely idiotic. Nobody in their right mind should be doing anything like this. And to put this into perspective, I was there in person at the Johnny Depp trial. And at the Johnny Depp trial, nobody talked to the jurors. I watched the jurors, because, you see the jurors, you can recognize the jurors when they're moving through the courthouse. And they moved through the courthouse like they were surrounded by a fucking bubble. Because nobody wanted to talk to them. Nobody wanted to be near them. No one wanted to bump into them in the hallway. Nobody wanted to be seen anything remotely like being near one of the jurors. I ended streams at times because jurors were too close. I picked up and moved because jurors were too close. This is, and the thing is, I wasn't the clerk of the court. I wasn't the bailiff. I wasn't the anything. I was some random dude that was there covering things, right? Just some rando person. And if I, as John Q. Rando, know to stay the fuck away from those jurors, then so does everyone else, right? Like, it's just 100%. You just know to stay away from them. And yeah, this is crazy to me. Like, I have never heard of anything like this happening in my area. So, all right, carrying on here. On May 13th, the Supreme Court of South Carolina unanimously reversed plaintiff's murder convictions and remanded for a new trial, holding that Ms. Hill's jury tampering violated Murdaugh's constitutional right to a fair trial by an impartial jury. Mr. Murdaugh brings this action to hold Ms. Hill accountable for wrongful conduct under color of state law and to recover compensatory and punitive damages as provided by law. Now, one of the things that's actually really, really helpful to really helpful for Murdaugh here is that there's a lot of court findings that have already determined that Becky Hill is a sack of shit, right? She has been adjudged by the court to be determined to be a sack of shit. And they may be able to use those rulings against her in order to, in order to get to a finding of, finding of responsibility, not guilt, but a finding of liability, right? So parties, Becky Hill, we know who Becky Hill is. Plaintiff, Richard Alexander Murdaugh, is a former attorney who was charged with the murders of his wife, Maggie, and Paul, and his murder convictions were vacated by a published opinion. So, yeah, this is the thing. Not just any sack of shit, a sack of shit as a matter of law, right? She has been adjudged to be garbage. There's not a lot of people out there that you can say that the court has determined that they are fucking awful. And in this case, that is where Becky Hill sits, right? The court has determined that she is the worst. So, jurisdiction and venue. They have subject matter jurisdiction. Yeah, we're going to skip over it. Jurisdiction's not a big deal here. Some cases, jurisdiction gets to be interesting. This is not one of them. Factual allegations, at least unless something really unusual happens. Factual allegations. Alex Murdaugh was indicted for the murder of his wife Maggie and son Paul on July 14th, 2022. His murder trial began January 23, 2023. The trial ran for 6 weeks, ending with convictions on the evening of March 2nd, 2023, and sentencing March 3rd, 2023. The state rested its case in chief, and the defense began its case on Friday, February 17th. Court was not held on February 20th, which was President's Day. After returning from the holiday, defendant Becky Hill began to enter the jury rooms often. As the defense began its case, Ms. Hill told jurors, "Y'all are going to hear things that will throw you all off. Don't let this distract you or mislead you." So she says this during the defense's case, right? And the defense is entitled to present evidence. The defense is entitled to present evidence and have it treated by the jurors exactly the same as the prosecution's evidence. But not just that. It's that they also, to a certain extent, it's actually that you have to treat the defense's evidence better than the prosecution's evidence. And what I mean by that is that the prosecution's evidence has to prove the case beyond a reasonable doubt, whereas the defense evidence has to only, it can just raise a reasonable doubt, even in the situation where the prosecution has prima facie proven its case, right? You can be done with the prosecution's case and be thinking, man, this fucker's guilty, right? And then Murdaugh stands up and he says, hey, here's what actually happened. Here's my side of the story. And the thing is you could think Murdaugh's lying. You could think Murdaugh, you don't believe him. But if what he tells you is possible, even if you think it's unlikely, but if you can get to maybe, then you have to acquit, right? So the prosecution's evidence, if it gets you to maybe, that's not an acquittal, right? That's not a conviction. That's an acquittal. That's, you got to acquit. You got to send the person up. You got to whatever. But you have to, it's a very different scenario for the defense. I had a case. It was not a murder case. It was a fraud case. And the judge, it was a bench trial because most trials in Canada are bench trials. The judge at the end of it said, quite frankly, I don't believe my client, right? The judge is like, I don't believe her. Don't believe her at all. but her story's possible. So I have to acquit, right? Even though I don't believe her, even though I think that that this is, that this is shit, the prosecution can't prove that it didn't happen that way. So it's possible, must acquit. And the judge did acquit. So that is that's a big deal, right? That is that's a huge thing. So, additionally, Ms. Hill and juror number 826, the new jury foreperson, on multiple occasions went to another room to have private conversations lasting 5 or 10 minutes. Sometimes they would go into the jury room's single occupancy bathroom together. Why are they going to the bathroom together? Why? What conversations are they having in the shitter that, four-person juror number 826 never said anything about the content of those conversations to other jurors. Ms. Hill even instructed jurors they could not ask four-person juror number 826 about the conversations. So, one of the things they are quite possibly doing here is they are quite possibly looking to go after juror number 826. Because if if juror number 826 was having secret meetings, and if juror number 826 was also on board with this, then juror 826 could be in some shit. Now, I see this. Everyone knows women go to the bathroom together, lol. It's a single occupancy bathroom. It is a one-person, single occupancy means they go in, there is the toilet, there is the sink, there is nothing, there is no hanging around space, there's no, whatever. It's, it's real close. So basically one person's got to be sitting in another person's lap. And that this is, because I know at a bar, you'll have 3 or 4 women will go to the bar, go to the bathroom together. They'll go and they'll stand by the mirrors, not in the stalls. They'll stand by the mirrors and, and chat, right? And discuss things and all of this. But they're not all going to pile into the bathroom stall, right? And just be sitting there and, and the thing is if you are having girl time or whatever, you are not going to be doing that. You shouldn't be doing that with the jurors, right? At all. So, yeah. And further, when she's telling the other jurors that they can't, that this is secret, what the fuck is that about? Right? What is that about? You're right. Runkle doesn't get it regarding women sharing an intimate space. You shouldn't be sharing an intimate space between the clerk of the court and a juror. You might be doing this with your buddies. You might be doing this with your friends, whatever else. But if the juror needs to throw up, Becky Hill does not get to be the person who holds her hair back. Right? That 100% that is, no, that is not how that works. So, yeah. 2 days later, on Thursday, February 23rd, and continuing through the next day, Mr. Murdaugh testified in his own defense. Before he began his testimony, Ms. Hill told jurors not to be fooled by the evidence. By the evidence Mr. Murdaugh's attorneys presented, which at least one juror understood to mean that Mr. Murdaugh would lie when he testified. Ms. Hill also instructed the jury to watch him closely, look at his actions, and to look at his movements, which at least one juror understood to mean that Mr. Murdaugh was guilty. Immediately after Mr. Murdaugh testified, four-person juror number 826 told the jury that Mr. Murdaugh was crying on cue. This is also not appropriate because they ain't deliberating yet. They should not be talking about their impressions of the evidence at this point, right? That's later for deliberation. She also criticized the former four-person, juror number 589, for handing Mr. Murdaugh a box of tissues when he was crying on the stand, because that is what the defense wants us to do. They shouldn't be taking sides, right? The next court day after Mr. Murdaugh's testimony, Monday, February 27th, Ms. Hill told the trial judge, the Honorable Clifton B. Newman, about a Facebook posting she purportedly saw in the evening of Friday, February 24th. By the way, just as a note here as well, all of this is allegations, right? And because this is a civil filing, they can make all sorts of allegations so long as they have a reasonable basis to allege them. But these are not proven allegations at this stage. They're things that they're things that have been alleged, but they may not end up being true, right? So, but this means that they're almost certainly going to be bringing juror number 826 in to ask questions. Juror number 826, they're going to be like, we have some questions. We have some thoughts. We have some, like, what you doing? Why? Why are you doing those things? So, yeah. All right. The next court date, they brought in the Facebook posting while perusing a Facebook group page called Walterboro Word of Mouth. The post, purportedly by juror number 785's ex-husband, allegedly stated that his ex-wife was saying she was on the jury and saying stuff about how her verdict was going to be. Why would you believe the ex-husband in the first place? Judge Newman asked Ms. Hill to produce a copy of the posting. She could not produce a copy, but according to Ms. Hill, a subordinate employee in the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post. Folks, I posted an ugly post yesterday to which I have deleted, and I kind of, in a roundabout way, directed it toward a certain person, and I would like to apologize to everyone who read it for that ugly for me to do that. And yes, I let Satan control me, and I broke down and started drinking. And when I was drunk, I made that post, and I'm sorry. Okay, I'm going to go on a little side rant here. Here is the side rant. The side rant is, stop blaming Satan for your shit. Because if Satan exists, Satan is the laziest supernatural being that has ever existed. Because Satan doesn't have to do shit. People do asshole shit all on their own. And so people are like, Satan did it. And Satan's like, I'm just drinking. Like, leave me the fuck alone. I didn't do this shit. It's like Satan sit like looking up from his beer going, I what now? Like, stop blaming Satan for your shit, because there isn't like a supernatural being making you do stupid shit. It's your own stupid shit. Like, Satan's like, nah, bro. So, yeah. Also, I am counting. I see that we got to 9 out of 10 on the goal. I am counting it as as we reached the goal, because I saw that multiple super chats came in right as the goal ended. I'm starting the thing over, But we will take a small interlude here. This one is actually kind of interesting. It is fire candy, is the the name on it. It is candied jalapeno sauce. So now some folks know I'm not the biggest fan of jalapeno as a flavor, because jalapeno's got a bit of a soapy kind of aftertaste. This one does not have a huge like a huge soapy aftertaste. It's there, but it's really low. Mostly it's kind of sugary and apple cider. I was wondering what else that was. So it tastes kind of sugar apple. It is not super spicy. It's actually quite reasonable. And you know what I want to try this on? I want to try this on like vanilla ice cream, because I don't know if you know this about me. I don't know if you've ever heard this. Vanilla ice cream goes actually really well with hot sauce. I know I'm weird for that, but it really actually does go really well with hot sauce. The spicy and creamy and cold all go together really well. So I actually think this would be really good on that, and I want to try it. The next one, I started another goal. The next one is going to be a bit of a challenge, and I'll tell you why. The next one is the Frig That's Hot sauce. So that one is a big one. Do I think cilantro tastes soapy? No, thankfully I don't have that gene. Cilantro just tastes good to me. So yeah. All right, here we go. The apology post states the initial post was already deleted on February 16, so it would have been impossible for Ms. Hill to see the original post on February 24th. So she lied. She lied is basically what that is alleging here, right? Juror number 785's ex-husband has averred in a sworn statement that he made no such posts. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity from January 23rd, 2023. I guess that would be the ex-husband, which confirms he did not post the apology. The supposed original post, if deleted, would not be recoverable under this point under Facebook's retention policies, and that he in fact never posted anything to the Walterboro word-of-mouth Facebook page during the trial. On February 28th, Ms. Hill questioned juror number 785 about the fictitious post on Walterboro word of mouth alone in her office in the courthouse. She told juror number 785 that someone had emailed her stating her ex-husband posted on the Walterboro word of mouth Facebook page that juror number 785 had been drinking with her ex-husband, and that while drunk, she expressed opinions on the guilt or innocence of Mr. Murdaugh. Juror number 785 told Ms. Hill that never happened, and that she'd not seen her ex-husband in 10 years. Juror number 785 asked to see the post, but Ms. Hill would not show it to her. Ms. Hill directly asked juror number 785 whether she was inclined to vote guilty or not guilty. This alone is incredibly improper, right? This is ridiculously out of bounds. You cannot ask this kind of thing. So juror number 785 said she had not made up her mind. Later that day, Ms. Hill told juror number 785 that the South Carolina Law Enforcement Division, SLED, and Colleton County Sheriff's Office personnel went to Mr. Stone's house, and he confirmed he made the post. This was a fabrication by Ms. Hill. Ms. Hill told juror number 785 that she would somehow reinstate a restraining order juror number 785 previously had against Mr. Stone, which is something that Ms. Hill did not have the authority to do. This is wild. Like, if you accept all of this as true, then basically we have a situation where she was like a major a major instigator of bad shit. So yeah, it's it's crazy to me, right? So yeah. All right. Still later that day, Judge Newman examined juror number 785 regarding both the non-existent Facebook post and the tenant coworker email in camera. Juror number 785 described her interactions with Ms. Hill regarding the Facebook post. She denied making any inappropriate comments about the case to third parties and stated she wanted to hear closing arguments before forming an opinion on Mr. Murdaugh's guilt or innocence. They also note a coworker of a tenant of juror number 785 emailed the court on February 27th stating that the tenant said her landlord was a juror and had expressed an opinion about the case when delivering a refrigerator to the property more than a week earlier. So, after juror number 785 was dismissed, Judge Newman said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. He was right to be concerned." If these allegations are true, then quite honestly, Becky Hill should be in jail, not probation, should be in jail. And I mean, quite frankly, if you are trying to tamper with this in order to get a conviction, then I think that there is there's a real argument that maybe she should face the punishment that Murdaugh would have faced, right? You wanted him to do 2 life sentences in, then, all right, that's the stakes, 2 life sentences. Did you see that Alex is suing Becky? Chrissy, we did see that. That is what we're covering right now. we are totally covering that right this second. So the next day, on March 1st, 2023, the jury visited Moselle, the site of the murders. During the visit, 4-person juror number 826 and Ms. Hill walked off to have yet another private conversation. In her book, Ms. Hill more vaguely hints at communicating her opinion on Mr. Murdaugh's guilt to the jury during the visit to the Moselle property. While the jurors viewed the Moselle property, we could all hear and see Alex's story was impossible. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. At that moment, many of us standing there knew. I knew, and they knew, that Alex was guilty. You shouldn't be knowing any of this, right? And in fact, the jurors shouldn't have made a decision on any of this yet. So that day, Judge Newman also held an in-camera conference regarding the tenant coworker email in which he decided to revisit the Facebook post issue with Ms. Hill. So court, okay, well, let me see what Becky's talking about. I wanted to revisit the Facebook post that you mentioned yesterday. Ms. Hill, right? Court, that's Becky Hill, the clerk of the court. Can you tell us about that Facebook post? Ms. Hill, yes, I think it was Friday evening. Just for a brief moment, I perused Facebook, got on Walterboro word of mouth, and saw where someone had said that, well, it was the ex-husband of a juror, and he said that he noticed that his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be, and that he was the ex-husband, but she was known for talking way too much. And then I just kept on scrolling because that was enough for me. I've gotten enough. Why on earth? Like, if you're the clerk of the court, why would you just keep on scrolling? I can tell you, if I was a court official and I saw that, like, there was this, I wouldn't be just like, oh, scroll on. I would be taking screenshots. I would be compiling a file, right? I wouldn't be reaching out to anybody. I'd be compiling stuff to pass on to, like, appropriate people, which would be like, hey, judge, here you go. And, yeah, then, once the then the judge can decide what to do with it, which will probably be that the judge will be like, all right, we're going to give this over to, we're going to give this to the defense. We're going to give this to the prosecution. We're going to ask them what they think that they should do. We're going to take it to the police. We're going to, all of these things, right? So, yeah. Yeah, that's because you're actually a professional. That's because I have 2 brain cells in my head and they have met on occasion. I have at least a couple of brain cells that have had a secret meeting in a bathroom stall to, and yeah. All right. So, and how did you determine who he was talking about? Ms. Hill, when I heard there was an email on Monday, I figured the 2 went together if it was true. Okay, so she just guessed? What the fuck? The court, well, she's confirmed she has an ex-husband who she has 3 restraining orders out against, so Ms. Hill, right. So if she's got 3 restraining orders out against this guy, how likely is it that they were hanging around drinking together? Right? How likely? So, I mean, it just makes no sense. So, yeah. All right. Yeah. So, just looking over at all of these things, and yeah. So Ms. Hill says, right. So then we looked on Monday after you told me to try to go back and look for it, and we couldn't find it. But then we found out his name. We found the post, and we printed it out where he said he'd put something up, but that he deleted at the time that he put something out there that wasn't nice. Court said, he said he got drunk afterwards. Mr. Meadors, something about the devil. Something about the devil. Mr. Harpootlian, didn't he say it was Satan in it? Ms. Hill, Satan was in it, yes. In all of the details, yes. The court, all right. Ms. Hill, made me do it. Court, okay. I just wanted to have that on the record. You're reading a Facebook post by the ex-husband who said it. Of course, you haven't talked with him, so you don't know where he got his information from. Ms. Hill, I don't. I can find it, though. Ms. Hill, your job is not to investigate. You should not go looking for Satan. Yeah. But Ms. Hill never saw any such Facebook post. She made it up. Further, she knew the apology post was not posted by juror number 785's ex-husband. Juror number 785 showed Ms. Hill a picture of ex-husband, which is not the Facebook profile picture of the other Mr. Stone's post about Satan. Satan is out here catching strays, and he's like, guys, I do not want to be associated with Becky Hill. I'm just Satan. I'm the, I'm just the, I'm just like the grand evil in the universe. I don't want to be, don't put us together. That's not cool. So the next day, March 2nd, 2023, the end of the verdict, juror number 785 received a call from her ex-husband that she did not answer. The call upset her because Ms. Hill's lies had led her to believe he was posting on Facebook about her and might be stalking her. Juror number 785 asked to speak with Ms. Hill. She told Ms. Hill she was scared. Ms. Hill told her that the Murdaughs probably got to him, meaning her ex-husband. So, yeah. All right. So the Murdaughs probably got to him, meaning her ex-husband. Are they sure it meant the ex-husband, or did it mean Satan? Ms. Hill once again asked her opinion regarding Mr. Murdaugh's guilt. Juror number 785 told her that Creighton Water's closing was good, but that she still had questions. Ms. Hill asked what questions, and juror number 785 replied she was concerned that no murder weapon was found. Ms. Hill then asked, well, what makes you think he's guilty? Juror number 785 said Paul's video at the dog kennels. Ms. Hill then told juror number 785 that everything Mr. Murdaugh has said has been lies and that I should forget about the guns. They will never be seen again. And that's a really, really weird phrase, right? Because Becky Hill is like, the guns will never be seen again. And I'm like, how do you know? That's the only thing that makes me go like, that particular statement is just so weird. Because I'm just like, is that, you know, like, it's weird, right? Because, I mean, in theory, they could find the guns anytime now, right? Somebody's gonna, like, it could be somebody's out magnet fishing, you know, in whatever South Carolina swamp and is like, hey, cool, a couple of ARs. What a lucky day. And yeah. So Ms. Hill then asked juror number 785 about the views of the rest of the jury, telling her that if the foreperson would just go in and ask for a raise in hands, this would be over and done with, and everyone needs to be on the same page. Juror number 785 went to the jury room and 10 minutes later was excused from the jury. In open court immediately after her excusal, juror number 785 asked Judge Newman if he'd spoken with the clerk of the court, referring to the conversation that morning with Ms. Hill. Judge Newman responded that I have not spoken with her today and that this is totally independent of any conversation regarding her ex-husband, apparently misunderstanding her question to refer to the issue of the Facebook post. When the jury began deliberations that evening, Ms. Hill told them that this shouldn't take us long and that if they deliberated past 11 p.m., they would be taken directly to a hotel, even though none were prepared to stay overnight. The thing is they almost never sequester jurors now, right? That is, they very, very rarely sequester jurors because it's expensive and it's difficult in the modern era. And quite frankly, in the modern era, I mean, yeah. I mean, and they're not going to take the jurors to a hotel without giving them a chance to, like, you know, pick up shit and, you know, be ready for it, right? So, yeah, it is frustrating. And yeah, it's bizarre. All right. The goal is at 1 out of 10. So we will, we'll see how this goes. All right. Ms. Hill told jurors that after the trial, they would be famous and predicted that the media would request interviews with them. Ms. Hill even handed out reporters' business cards to jurors during the trial. Why the fuck are you giving reporters business cards? Like, the clerk of the court does not work for the reporters. I mean, reporters shouldn't like the clerk of the court because the clerk of the court shouldn't be doing them favors. They should just be doing an impartial thing. And so when the clerk of the court is, or if a reporter's like, hey, here's some business cards, can you give those to the jury? You should look at the reporter dead in the face, reach over, drop those cards into a trash can and say, fuck you, no. Right? That's how this works. Because the jurors should not be thinking about newspaper interviews, right? They shouldn't. So Juror number 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. Because I guess he already figured out that he needed to do an interview. So, after the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters from a network news show. She traveled with jurors to New York City when they appeared on the Today Show. Ms. Hill got her book deal. Her book, Behind the Doors of Justice, was released on August 1st, 2023. She'd been planning to write a book about the trial even before it began. In the period leading up to the trial, she repeatedly told coworkers that a guilty verdict would sell more books and that she needed to sell books because she needed a lake house. She wants this. She wants this real bad. She wants it so bad that, yeah. Ms. Hill's book, however, caused some jurors to come forward to describe her efforts to obtain her desired guilty verdict through jury tampering during trial. In August 2023, several jurors provided affidavits or statements to Mr. Murdaugh's defense counsel describing Ms. Hill's jury tampering. On September 5th, 2023, Mr. Murdaugh filed a motion with the South Carolina Court of Appeals for leave to file a motion for a new trial based on the evidence of Ms. Hill's jury tampering. Court of Appeals granted the motion, and yeah. They asked to prohibit Judge Newman, but Judge Newman recused himself, so that worked. And then Judge Toll was brought on for the new judge. Trial court ordered an evidentiary hearing. Jurors identified by anonymous letters testified as follows. CFLEO, YWQ, and K testified that they did not hear Ms. Hill's comments on the merits of the case before the verdict. Juror P testified that he heard Ms. Hill tell jurors regarding Mr. Murdaugh's decision to testify in his own defense to watch his body language. Juror X testified, the epic day and that it was rare for a defendant to testify. Juror Z, or Z, if you're Canadian, testified that she heard Ms. Hill comment to watch Mr. Murdaugh's actions and to watch him closely. And Juror Z testified that the comments did affect her verdict. So, all right. The trial court then examined Juror Z regarding her affidavit attached to Mr. Murdaugh's motion for a new trial, and she affirmed each paragraph therein, including affirmance that during trial, Ms. Hill told the jury not to be fooled, etc. Ms. Hill testified after the jurors. She got up and she's like, I'm gonna testify. That's gonna help. She denied engaging in any jury tampering. She also denied stating that she wanted a guilty verdict to promote book sales. She admitted she plagiarized portions of her book and that her profits from its sale were, in the 6 months before it was withdrawn from publication, because of her plagiarism, were approximately $100,000. That's actually pretty good, right? $100,000 is actually pretty solid for all of that. She admitted the book contained unfounded statements included for poetic license or literary ease. Examination by the trial court revealed that Ms. Hill's denial during direct examination of questioning a juror during the murder trial was not truthful, and that in fact she did want a guilty verdict. Barnwell County Clerk of Court Rhonda McElveen testified next to rebut Ms. Hill's denial that she wanted a guilty verdict to promote book sales. McElveen was assisting in the courtroom during the murder trial. She testified. Question. And did she discuss with you, what, if anything, did she discuss with you about how she felt the verdict should turn out to be in the Murdaugh trial vis-a-vis in reference to the book? What would help the book? Answer. A guilty verdict. Question. Tell the judge and me what exactly she said to you that you remember. This is prior to the trial. Answer. Okay, well, first of all, she said we might want to write a book because she needed a lake house and I needed to retire. And from then, further conversation was that a guilty verdict would sell more books, and we left it at that. This was before, even in December. And when did she say? Did she ever say that again to you during the weeks you spent there? several times. It could be said it was, among friends in her office, or we might be having dinner, that kind of stuff. But that's about it. That she needed a guilty verdict to sell more books? That it would be the best way to sell books. Yes, sir. The best way to sell books. Now, during this process, did she ever express to you an opinion on whether or not, in fact, was Mr. Murdaugh guilty of the murders of his son and his wife? Yes, sir. Tell me what she said, and if you remember when. I don't exactly remember when. I know it's over half of the trial had already happened, but the evidence was coming forth that it looked like he might be guilty. She made a comment that guilty verdict would be better for the sale of books. Ms. McGelveen also testified that Ms. Hill made comments to her like, "Don't be fooled by the evidence presented by Mr. Murdaugh's attorneys, identical to statements reported by some jurors." And she testified that Ms. Hill insisted on allowing a book writer, who wrote the foreword to Ms. Hill's book, to sit in the well of the court during trial, where she could see sealed exhibits under the subterfuge of being a Sunday school teacher. Why would you let a Sunday school teacher do that? Like, why? This makes no sense. Like, the excuse makes no sense. So I don't I don't get it, like, at all. This is such a mind-cruggling case. The final witness was the alternate juror, juror number 741. She testified that Ms. Hill told jurors the defense is about to do their side, and they're going to say things that will try to confuse you, but don't let them confuse you or convince you or throw you off. I mean, don't let them convince you? The defense has a right to try to convince the jury. That's why they're there, right? That is the purpose of the defense. The defense isn't there for, like, they're not just there to, like, to hang out. They're not just there because they, like, need a place to be or something. They're there because they want to convince the jury. At the conclusion of the hearing, the trial court ruled from the bench. Did clerk of the court Hill make any comments to any juror which expressed her opinion what the verdict would be? Ms. Hill denies doing so, and so the question becomes, was her denial credible? I find that the clerk of the court is not completely credible as a witness. Yeah. Ms. Hill was attracted by the siren call of celebrity. She wanted to write a book about the trial and expressed that as early as November 2022, long before the trial began. She denies that this is so, but I find she stated to the clerk of the court, Rhonda McGelveen, and others her desire for a guilty verdict because it would sell more books, or sell books. She made comments about Murdaugh's demeanor as he testified, and she made some of those comments before he testified to at least one and maybe more jurors. Clerk of the court allowed public attention to the moment to overcome her duty. Trial court nevertheless denied the motion for a new trial. By the way, Judge Toll she kind of got spanked by the Court of Appeal, because the Court of Appeal is like, yeah, you definitely should have allowed a new trial, right? So trial court nevertheless denied the motion, and they said that there's no presumption of prejudice from tampering with the jurors, and Mr. Murdaugh failed to prove that Ms. Hill's comments changed the jury's verdict. The Court of Appeal is like, yeah, that is some bullshit. That is wrong. May 2024, it was reported that the State Ethics Commission had referred ethics complaints against Ms. Hill for criminal prosecution. May 14th, she was arrested and charged with perjury, obstruction of justice, and misconduct in office. She pleaded guilty to those charges. Her perjury conviction concerned her testimony at the evidentiary hearing for Mr. Murdaugh's motion for a new trial, in which she testified she did not give news media access to sealed trial exhibits, including crime scene photographs of Maggie and Paul Murdaugh's slain bodies. Forensic evidence, however, conclusively proved she escorted news media news media to secured areas of the courthouse after hours, where she allowed them to photograph sealed exhibits. Ms. Hill attempted to profit from Maggie and Paul's murders, not only by advising the jury to convict Mr. Murdaugh, so she could write a book about his conviction, but even by selling access to grisly photographs of their slain bodies. On May 13th, the Supreme Court, or the South Carolina Supreme Court, vacated the order denying the motion for a new trial. All right, skipping ahead a little bit here because it is somewhat repetitive. They note, following the revelation of Mr. Murdaugh's financial crimes, the South Carolina court placed him in receivership. Mr. Murdaugh had funded his murder trial defense with a $600,000 withdrawal from his 401k retirement funds. $600,000 is a lot of money. So if you're wondering what it costs to run a 6-week trial, $600,000 is, yeah. This withdrawal to fund his legal defense was authorized by the court overseeing the receivership. These retirement funds were employer contributions to his retirement account, untainted by any criminal activity, and were his sole remaining asset. Not anymore. Mr. Murdaugh spent the entire $600,000 on his trial defense. The South Carolina has ruled that Ms. Hill's actions, motivated by her own desire to profit from the trial, caused these funds to be lost. So basically, he's like, I want my money back. Now, here's the problem. I don't think Ms. Becky Hill has $600,000. I really doubt that she does. Because, like, where would she get $600,000 from? We're going to start a goal here, and it'll be, Runkle, have a drink. Because the hot sauce goals are not goaling, so we're going to start with a... I got a new Paloma thing that I have yet to try. It is a prickly pear Paloma can. I don't know if it's any good, but we'll give it a try. So I started a goal for that. But I mean, largely what he can go after is the lake house she is imagining. It's an imaginary lake house, right? It doesn't exist. She never got it. Now, the $100,000, maybe she's got that. Maybe she spent it, right? Maybe that's gone. But I can certainly see why he'd be like, I want every fucking dollar she's got. I want everything she's got. I want to mine her retirement, funds. I want to, yeah. And if we hit the goal, I'll also have the hot sauce because I'll have the hot sauce and rinse it down with the thing. So, yeah. All right. So, what do we got here? Poot said in an interview, either press conference or an interview, that the money will go to people he owes from financial cases. Yeah, I mean, none of this money is going to end up... Like, there's so many people that Poot owes money to. Like, this is not going into his commissary. He's not going to be like a soup king in prison, right? He's not going to be the guy who's got all the soups. So, yeah. Jury tampering in violation of the... Murdaugh, not Poot. Yeah, fair enough. Whichever. Jury tampering in violation of the 6th and 14th Amendment. So, yes. Murdaugh is not going to be a wealthy guy in prison, right? He's, yeah. Murdaugh wins beef sticks via card games. Please tell me that's not a euphemism. Please tell me that is not a euphemism. Because, yeah. As set forth above, Mr. Murdaugh's right to a trial was violated. So what is he... as a result of Ms. Hill's actions, Mr. Murdaugh suffered monetary damages of $600,000. And as set forth above, Ms. Hill's conduct was motivated by evil motive or intent. Not Satan, just regular evil, right? Regular evil. And involved reckless or callous indifference to Mr. Murdaugh's federally protected right to trial before an impartial jury, including Ms. Hill's desire to profit personally from Mr. Murdaugh's trial. Mr. Murdaugh, therefore, is entitled to an award of punitive damages, and he wants attorney's fees and costs. So, yeah. Prayer. So he wants some sufficient to adequately compensate him for all of those things, and he wants a jury trial. So he's suing. It's going to be real interesting to see how this goes. But I'm curious as to whether that juror ends up getting in some shit, right? I'm wondering, when somebody says prayer, it's what's called the prayer for relief. The prayer for relief is, and I don't know why they call it the prayer for relief. It's weird to pray to a court, right? But the prayer for relief is what you're asking the court to do. It's so like, you know, whatever you're asking for is what goes in the prayer for relief. It's like, I want money, I want an injunction, I want a pony, I want, you know, a brand new car, I want, you know, whatever else. You know, all of those things go into the prayer for relief, right? And it's the prayer for relief because this is the shit you're asking for. And yeah. So it's not a prayer to not a prayer to, you know, God or Satan or any other, like, you know, any other supernatural entity. It's a prayer to the court, right? And so yeah, at the end of the day, that's what they're looking for. So I don't know sort of where that's going, but that's kind of the game plan. All right, so let's go, and I don't know which topic. Somebody wanted to cover Mangione. Somebody very much wanted to cover Mangione, and so we can do that. That is 17 pages, which isn't too bad. And then we can cover Chud as the end. So, all right. Yeah, prayer in the 18th century sense that the courts use, meaning request. All right, so let's cover Luigi Mangione. And before we go to Mangione, I just want to say, if anyone murders me, I really hope that, A, I'm more likable than an insurance company representative, and B, I hope that whoever murders me is not pretty, because I feel like Mangione gets a lot of I feel like he gets a lot of people who like him, in part because of him being an attractive guy. Prickly pears are good frozen and likely in a paloma. Have you ever had a michelada? I love a michelada. So there's a place that there's a Mexican place near me, and yeah, I get a michelada whenever I go down there, and I am a fan. So we're gonna swoop. We're gonna read super chats, and then we're gonna swoop again. So here we go. Which is a good swoop? I really like this swoop. Just Potter and Zora hanging out, having a good time in the backyard. I've got to get some more video footage of Potter and Zora to make more swoops, because I think some of those swoops maybe I should, like, not retire, but you know, maybe rotate, if that makes sense. Oh, there's a good question. Is Zora still on her diet? Zora is on her diet. Zora is not happy about her diet. Zora is getting to be a bit of a shit about her diet. And the reason why I say he's being a bit of a shit is that, or she's being a bit of a shit, is that, how do I put this? Potter has, like, his appetite is not the best. He's eating, but his appetite is not the best. And so Zora is, like, trying to get in there and tries to, like, bully Potter out of the last bit of his food. And the other thing about what she does is that when Zora is, or when Potter is done eating, Zora will swoop in and she will lick his bowl clean. She's like, I'm gonna help, right? And it's like, Zora, you are not dying of starvation. You're okay. And she's like, no, I am dying. Like, I am so dying. Zora is also kind of pissed at me right now. And the reason why she's pissed at me right now is because Mrs. Runkle is having dinner and watching a movie with her family, like my mother and father-in-law. And it's not a movie I wanted to go to. It is Sheep Detectives. And so she's pissed at me because I am not Mrs. Runkle. And she's like, when are you going to be Mrs. Runkle again? And I'm like, I can't do that. She's like, and the other thing, she associates putting her, she associates her leash with going to the in-laws' place. And so Zora has 3 times now. Zora has gone and she's taken her leash off the wall and she has brought the leash to me and she's been like, take me to the place. And I'm like, no, Zora. No, we're not doing that. We're not able to. And she's like, but I wants to. So she's like, take me. So Aqua says, that reminds me of Rob. Yeah, I got to, yeah. I'm hoping to see Rob soon-ish, but I got to actually book some things and all of those things. So Donnie Not Wahlberg, towards your Chicago meetup. If you haven't heard, the Chicago meetup is the 30th of May this month. It is in not even 2 weeks. It is real soon. And so this is going to be at the Green Door Tavern, which is at least partially wheelchair accessible. They've said that they can handle a wheelchair. There's a place that's more wheelchair accessible, but they didn't answer me until yesterday at like 9 at night. If I do another meetup in Chicago, I might do it at the other place. But they were like, yeah, sorry. But Green Door Tavern on the 30th, 6 p.m. until we give up, right? Until we go away. And so there is a minimum spend. You don't have to worry about the minimum spend. I have to worry about the minimum spend. Oh, I know where the tie is. I'm an idiot. Chat. People were wondering where the tie is. It was right in freaking front of me. And the reason why it was in front of me is because I wore it for like a Zoom court thing. And then once I wore it, once I was done with court, I hate wearing ties. So I pulled the tie off and I just went yeet. And tie is right there. So, yes. Anyway, so this thing has a $1,500 minimum spend. That is for me. If people don't show up, then I owe the bar $1,500. So I hope people will show up. But I also bought, I think I bought 3 appetizers just to get people started. So I bought some like Chicago deviled eggs. I'm curious about what that means. I bought some other things. And so those will be there. After that, people can order stuff for themselves because that's not going to be enough for things. Law Talk with Mike is expected to be there. The Modas are expected to be there. And so I'm hopeful. So yes, Law Talk with Mike and the Modas. I've met the Modas in person before. I've never met Law Talk with Mike in person before. I am really looking forward to it. I am gonna try to get some video footage. Maybe I will try to get. I'll try to get somebody to record me trying Malort, because I've never actually drank Malort. I've come close. I've smelled it. Malort is awful. It is really, really bad. And yeah. So yeah, we'll probably, but yeah. I'm hoping you guys will be there because I really just I've done meetups in the past, and I just I enjoy meeting people. All sorts of people come out to the meetups, and you know what? I have yet to meet a jerk at one of my meetups, which means it's probably me. I'm probably the jerk, right? But I've met a lot of really interesting people. I've really what do you call it? I've really enjoyed them in the past. I'm looking forward to it. I'm looking forward to it this time. So I hope you guys will join me. So yeah. It's me, Tony P. Becky Lasai. Hill is an idiot. Thanks for covering this. She is an idiot. Phoenix Fire, thank you for being a member. Much appreciated. Patricia, happy 24th weekend, Canadians. Thank you. It is Victoria Day, I believe. Robert Ankeny, or Ankeny, I'm not sure. Talking about books. What books on the legal system or legal theory philosophy do you recommend to viewers of your channel rather than law students? I have a criminal justice minor and am joining a legal AI startup. Ooh, that's a rough startup. I've got a book, Wrongfully Convicted, that is not a bad book. Let's see, what else? What's another good book to recommend here? I'm just eyeballing my bookshelf. Some of these books I got to throw away, but some of them I'm like, not all of them are things that I could recommend as like legal books, because like I've got a whole bunch of Pratchett up on that wall. I got my Raymond Chandler collection. Ooh, I got to read that again. Maybe I'll bring that with me to read on the plane. Let me think on it. Let me think on that one. Because, yeah. The Limits of Boundaries is interesting, but it's kind of limited to... it's kind of limited to, like, local law, if that makes sense. Let me think on it. I actually... You know what I will say for a decent book to read? I will say the Rumpole books. If you can pick up the Rumpole books, they're not always like 100%, but they actually have a lot to... they have a lot in common with... they have a lot in common with like actual criminal practice. So, yeah. I'm halfway through Project Hail Mary. That was a really good book. You want to read Terry Pratchett and Raymond Chandler? I mean, I've read everything. I think I've read everything Terry Pratchett's ever written. And, Raymond Chandler, I know I've read everything he's ever written. So, yeah. Are people allowed to bring board games to the meetup? Yes, although we'll have to see if we have enough room to set them up. But, I mean, it can't hurt to bring them. I have Project Hail Mary on hold at the library. I'm 20th in line. I recommend it. It's a great book. Yeah. Did you watch the new episode of Good Omens? There's a new episode? I haven't. I have not seen that. I haven't read Chandler since my crime fiction and film noir class. Okay. I have our next goal. And the next goal is going to be a rant. So, Runkle Rant, RE, Detective Fiction class. All right. That is our next goal. Is I will go on one hell of a rant. So yeah, that will be a thing. All right. Let's see what else here. We got that. Denver. Okay, wouldn't take the $20. How about this for Mangione next? You got it. You do you, Ian. We got Mangione next. DSN, thank you for being a member. And thank you for the gifted membership. Much appreciated. The Jet JJ for the goal. Pammers TN, Jim and Dick have already told the jurors to lawyer up. 3 people went to the dog kennels. 1 came back. Paul almost caught the entire thing on Snapchat. It was the Murdaugh courthouse. They knew Becky. Yeah, it's a bit of a shit show. I don't know why they're retrying him, to be honest, because he's already going to die in jail. But apparently they might seek the death penalty if they retry him. So that's a whole thing. Victor Mann says, why are they not also suing the deep pockets of Colleton County? How much can they realistically get from Courthouse Becky? I don't know. There might be a procedural thing. Law-abiding rebel, this is making me even angrier that they didn't charge her with jury tampering. They should have. Melody says, I'm late, but I'm going to wrap the goal. Thank you so much. Laura Christine, thank you. The Lady Draconis, thank you so much. And excuse me, thank you as well. Alessi's Fantabulous Lexicon. I'm a woman. I don't go hang out with my girlfriends in a single occupancy toilet. That is not a thing, and especially routine secret meetings with an officer of the court. Like, I don't know. I've been in a lot of like social circles where women go to, go hang out in the bathroom. They never did it where it was single occupancy, though. Yeah. If I recall correctly, Murdaugh's financial crimes were not widely known at the time of the murders. The firm was getting suspicious, and Maggie was bouncing checks because he was $300,000 overdrawn at the bank. I do not know how I could get... Like, if I went to the bank... the bank recently offered me $5,000 in overdraft protection. Right? $5,000. I could not get to $300,000 overdraft. Like, it's just no, could not happen. Satan can't make you do anything. He just tempts. Morgana says they have a candied habanero as well that is fantastic. Ooh, I will have to try that. Fiona W says goal. Thank you. Philia Lynn, let's try the hottest one. That is the one. I think it's the hottest. They've got a couple of really hot ones, and the frig that's hot is one of the is either like the hottest or it's up there. Because it's one of those sauces that I find challenging. We'll put it that way. Have a drink and some hot sauce. Thank you. Fiona W says enjoy the drink. We are ready on the drink. Out of curiosity, when he gets a new trial, will the first trial go away? The first trial is gone. Or can they use Alex's testimony against him? Oh, they can use his testimony, most likely. Or did Becky F that up too? His testimony is likely admissible. There are wrinkles to it, but, his testimony is likely admissible. We could get into that in another stream. There's rules about like that. But Luna Dewdrops, have a drink, Runkle. Have you ever had an actual prickly pear? Yes. My dad used to stop on the side of the road and pick someone when we drive to Mexico. As I recall, it was a bit of a pain in the ass to eat. Because, if I'm thinking of the right thing. Masterful Melon, have a drink and a hot sauce. I will do that. On the plane to Alaska, glad to catch a live. Definitely not going to be a boring flight. I'm surprised you're getting good enough internet to stream. And Janeski, thank you so much. Luna Dewdrops, drink. Potter and Zora swoops and appearances are always appropriate. I love the dogs. Hunk Banana, no. As a relatively recently diagnosed diabetic, I can relate to Zora being a shit about her diet. Same, girl. Same. I love food so much that I fear any of the things that like restrict food, because like if they say, oh, you can't have hot sauce, I'm just going to look at my doctor and be like, Doc, how long do I have to live? Because I cannot, like, I am not, not going to be able to do that. So, yeah. Saw Rob posting on X a few days ago. Seemed wound up about some stuff going on in Virginia. Glad he's among the land of the living. He is. What was it? Will Alberta separate? All signs point to no, but we'll have to see. Honk Banana, no. Every time I see Becky Hill written down, I hear yakety sax played off key. Love it. Pamela Wissenbach for the Runkle rant. Yes. Kay Paris, ready for the rant. Oh, it's a good one. Miss Erica Claus says for the ranting Runkle. And Fiona says, I enjoy a good rant. And MDL, a rule is try to avoid Satan. You're not wrong. Although you spelt that, isn't that like a food or a meat substitute? The way you spelled it. So, yeah. Poot said they cannot use his testimony against him and he hasn't given up his Fifth Amendment right. Oh, interesting. Interesting. What's the latest on the gun grab? They're doing the business thing again, and then we'll have to see. Do you think you'd survive if you got that tick disease that makes you allergic to red meat? No, I would die. So, yeah. Kyle Aiden Fox says, Runkle, I was working on a bunch of gluten-free stuff for tour camp, and if I were told I could not have gluten, I would be like, how bad would it be? And keep on doing it. Yes. Also, speaking of rants, don't forget Rumble. You're not wrong. Let's go have a look at Rumble. How are we on the okay. Why is Rumble so awful at working with StreamYard? I got to and I see Drex is unused. Baldo says Satan keeps getting dragged into this and just wants to be left alone to continue giving Hitler hourly pineapple colonoscopies. If he did something up here, he wouldn't be caught unless he wanted to. You're not wrong. So, all right. And we have rant. All right. Where are we at on the goal there? And we got Runkle rant. Are we at the goal? We are not at the goal yet. Okay. Let's do another swoop. Let's do the eyebrow swoop. I like the eyebrow swoop. Crazy Cat Queen says, Runkle rant, please. I'm sure we'll get to the Runkle rant here, but let's dive in to Luigi. Not the way some of the people on like Twitter would like to, but so people of the state of New York against Luigi Mangione. So on December 4th, 2024, Brian Thompson, the CEO of United Healthcare, was shot to death outside the Hilton Hotel. Oh, I also owe you guys the what do you think? Oh, right, I got to pull the paper out. Yeah, here we go. Sealed for freshness. I thought it was saying sealed for my protection. I was like, you don't need to protect me from hot sauce. All right, here we go. Let's I'm a little nervous because I know this is a nasty hot sauce there. And like this one is a challenge. So here we go. Deep breath. Whew. Okay. This one is called the Frig That's Hot. It is not kidding. It is. I find this to be a 9 or a 10 out of 10 hot sauce. And like in terms of heat, it's got good flavor. I like the flavor, but oh man, it kicks. Little bit of a sour or bitter aftertaste. Little bit bitter at the end, but it's pretty good. Have Habaneros is the first ingredient. Vinegar, water, tomatoes, apples, pure maple syrup. Oh, that's nice. Salt, xanthan gum, vitamin C. Yeah, I mean this is a potent hot sauce, but it is a nice. I like the habanero forward. I really do. So, yeah. All right, and we have a Paloma prickly pear. By the way, I would not recommend this sauce if you are not a hot fan, because that is gonna this is gonna hurt. This is the Maritime Madness. So, yeah. Honk Banana Nose says, please use this to buy some little goddamn spoons. You're not just shooting hot sauce from the bottle anymore. So, I have a funny story about this, and I say it's a funny story because I found this this item a little bit ago. It had fallen behind the behind the or under the desk, and so I found it while I was putting my new speakers in. Ages ago, I bought a bottle of pure capsaicin, like pure capsaicin. I haven't tried it, but it came with a little spoon, like just a like it's like a teaspoon. And the thing is I want to know what fucking rocket surgeon thought I'm selling capsaicin, pure capsaicin, and I'm gonna sell it with a teaspoon. Because who the hell is taking an entire teaspoon of pure capsaicin? A teaspoon of pure capsaicin is enough to, that's like enough to murder like 30 people or more. It's just like, if you put a teaspoon of pure capsaicin into a keg of beer, you would probably make it undrinkable. So, like, I just, I don't get it at all. Like, just makes no sense to me. Okay, so, yeah, there's that. All right, let's dive into covering Mangione stuff here. All right. So Brian Thompson was shot to death outside the Hilton Hotel in Midtown Manhattan. The defendant was arrested at a McDonald's in Altoona, Pennsylvania. Now, if you're wondering what Altoona is noted for, Altoona is famous for Altoona-style pizza. And I want to show you what Altoona-style pizza looks like. Because, yeah, this is Altoona pizza. And so, I feel like murder, no matter what kind of murder, is no more than like the second worst thing to happen in Altoona, because this is a war crime. Like, you don't even need a war for this to be a war crime. This is fucking horrible, right? I mean, I'd try it, but that is awful, right? That is the worst thing I have seen. Like, when people are like, hey, you should try this food, I'm like, are you kidding? So yeah, I don't know. Yeah, I mean, and I'm the guy who tried surströmming, and I was like, yeah, surströmming is, is not a problem. We'll do that, but this looks like somebody ordered like, a pizza off Wish.com. So, yeah. All right. After he was recognized by employees who had seen media coverage. A 9mm gun was recovered from the defendant's backpack, as well, among other items, a loaded magazine, a silencer, cash, passport, and a notebook. Defendant has moved to suppress the evidence recovered, as well as statements made to law enforcement officers during and after his arrest. Somebody says, you were okay with surströmming? Actually, the surströmming was pretty good. I would eat surströmming again if it wasn't like $100 to get a can shipped here. It's really expensive to have a can shipped from Sweden to here, but I would eat it again. 100% I'd eat it again. So on September 16th, this court ordered Mapp and Huntley hearings, and those hearings were held in December, during which the court heard testimony from 17 witnesses. Both parties filed written submissions for the reasons stated below. The motion is granted in part and denied in part. Now you might be saying, oh, granted in part. Excellent. They granted the part that he cares about least. So, yeah. The arrest at McDonald's. The facts relevant to the hearing are largely undisputed. Several officers from the Altoona Police Department testified, and their body-worn camera footage was introduced into evidence. And I'm just going to interrupt here because I see this one. Pili Aloha Robertson. Toast to my dad. He's recovering from a minor stroke. My other account, Cootie Pootie Tootie, won't super chat. Cheers to your dad. I hope he recovers. I hope he recovers well, because that's rough. And so, cheers. All right. On December 9th, the defendant bought food at the Altoona McDonald's and sat in a back area to eat. A McDonald's employee called 911 to report that the defendant resembled the suspect in the Thompson killing. Altoona police officers Joseph Detweiler and Tyler Fry responded to the scene at about 9:30 a.m. Detweiler was a 14-year veteran of the police department who was familiar with the videos and news related to the Thompson killing, while Fry was a rookie officer who knew very little about the shooting. And the moral of this story is, don't go to McDonald's because McDonald's are narcs. Detweiler and Fry saw the defendant sitting at a back table near the bathrooms with a backpack sitting on the floor near his feet and a laptop in front of him. When the defendant pulled down his face mask upon Detweiler's request, Detweiler immediately recognized the defendant as the New York City shooter. When asked for his name, defendant responded that it was Mark Rosario, and when asked for identification, defendant produced a New Jersey driver's license in that name. While Fry went to verify the license in the NCIC database, Detweiler asked the defendant questions about where he was from and whether he'd been to New York recently. Detweiler then had the defendant stand up and frisked him, but did not find any weapons or contraband. So Fry then stood next to the defendant while Detweiler went outside to call Lieutenant Tom Hanley at the station, telling them that he was about 100% sure that the defendant was the New York City shooter and asking him to come to the McDonald's. Lieutenant Hanley then headed for the McDonald's along with Sergeant John Burns, Corporal Garrett Trent, and Officer Samuel McCoy. I just want to note that if this guy had ordered like room service, he would not have been arrested here. Detweiler returned to the table, again asking the defendant if he was from New Jersey, what he was doing in Altoona, and whether he'd been to New York recently. Defendant said that he had not. He also stated that he was homeless. Detweiler told the defendant that they were just trying to confirm his identity and that he would then be able to leave, although Detweiler conceded that he had no intention of letting the defendant leave. In response to further questions, the defendant said he was from the DMV area, apparently a reference to the acronym for the District of Columbia, Maryland, and Virginia. I like calling it the DMV area because it's DC, Maryland, and Virginia. It's the government area. So I'm from the DMV area where all the government shit is. It's like, that is fucking funny. So, all right. As Sergeant Burns and Corporal Trent arrived, Burns asked Detweiler if the defendant had been frisked, and Detweiler responded that he had. About a minute later, officers McCoy and Luke, the real McCoy, and Luke Yeager also arrived at the McDonald's and went toward the back area where the defendant was seated. Another officer, Corporal Brian Miller, also arrived at about the same time and went toward the back of the McDonald's. Detweiler asked McCoy to stand next to the defendant at about 9:42 a.m., while Detweiler and Hanley spoke outside. Fry, McCoy, and Yeager continued to stand next to the defendant. Hanley testified that he considered the defendant detained at this point. While speaking outside, I mean, the guy's obviously detained at this point. There's a bunch of officers who are, surrounding this guy and are clearly not going to let him go, right? So, is he detained? Obs, right? Obviously, he is detained. It's like, are you detained? Well, I'm only surrounded by like 18 cops now. So while speaking outside, Detweiler repeated to Hanley that the defendant was 100% the person wanted in New York City. Burns and Trent joined them outside where they pulled up photos of the suspect on their phones. Inside, McCoy asked the defendant if the backpack and laptop belonged to him, and he responded that they did. McCoy moved them to a table about 9 feet away from the defendant. That is sensible. Two more officers, Christy Wasser and Stephen Fox, entered the back of the McDonald's at about this time. So now they're up to like 70 cops. Hanley called the turnkey officer at headquarters and asked them to run the Mark Rosario license through the NCIC system. No record was found. Hanley told Detweiler to give the defendant false ID warnings required by Pennsylvania law. Detweiler then told the defendant he would be arrested for false ID if he gave the police a false name, and he asked the defendant if his name was actually Mark Rosario, to which the defendant responded, "No, sir." Detweiler then asked for his actual name and date of birth, which the defendant provided. Defendant also acknowledged having a fake ID. Asked by Fox why he had lied, defendant replied, "Clearly, I shouldn't have." Asked again by Fry why he had done so, the defendant replied, "That was the ID I had in my wallet. I had a fake ID." So, at about 9:48 a.m., Corporal Trent directed Fox to read defendant Miranda warnings, and Fox did so. When Fox asked the defendant if he wished to speak to them, he shook his head, also stating, "No, I don't think." Fox told the defendant he was not in custody at this point. He's only surrounded by like 60 cops, and they're not going to let him leave. And they're like, "No, you're not in custody." Of course he's in fucking custody. Fox continued to ask the defendant why he had a fake ID, and the defendant responded that he was going to remain silent. Fox ordered the defendant to stand and frisked him again. Defendant volunteered that he was carrying a jar of peanut butter. I'm surprised they're not charging him with like possession of peanut butter out of like some notion that he was going to use the peanut butter as a weapon against some person with a peanut allergy or something. So when Fox asked if he had any weapons, the defendant first said no, but then stated that he had a pocket knife. Sergeant Burns then relayed an instruction to Fox to handcuff the defendant, and he did so. After Fox retrieved the knife, he added it to the table where the backpack and laptop had been placed. I like how they frisked this guy. They're frisking this guy, and they fail to find his pocket knife, so no pocket knife. That they miss. They also somehow miss an entire thing of peanut butter. So this must have been the laziest frisking of all time, right? It's like they're just pulling out all sorts of shit like some sort of clown college skit. And Hanley reached out to the Blair County DA's office to determine what charges to file, ultimately settling on forgery and tampering. At about 9:58 a.m., Hanley instructed the officers to place the defendant under arrest, and as Detweiler and Fry each took defendant by an arm, Wasser began to put on a pair of blue rubber gloves. McCoy, nothing good happens in a room where someone else is wearing blue rubber gloves. I'm just saying. Blue rubber gloves are one of those things that's just like, it is a prelude to something unhappy. So McCoy confirmed that they were arresting the defendant for tampering and announced on the radio that the defendant could be marked as in custody. Officers Detweiler, Fry, and McCoy searched the defendant's pockets and clothing, recovering the jar of peanut butter. So again, they managed to completely miss a jar of peanut butter. Also, I liked the mask. It's like one of the few Jim Carrey movies that I like. But jar of peanut butter, a pouch with money, some coins, gloves, papers, a hat, and some string. Look out, he's got string. As Fox approached the table where the backpack was, he asked the defendant if there was anything in the bag they needed to know about. Defendant responded that he was just going to remain silent. Wasser and Fox then proceeded to search the defendant's backpack. As they did so, employees and customers continued to walk through the back area to access a closet or the bathroom. So, Wasser unzipped the backpack's main compartment and recovered removed a sandwich as well as a loaf of bread. Okay, this guy's very dangerous. So, as they continued to look through the backpack, Corporal Trent approached and suggested they go through that back at the station. Wasser responded, I don't know, just want to make sure there's nothing in there that's gonna... Fox joked that he would rather have a bomb here than down at the station. Wasser responded, laughing, that she did not want to pull a Moser, a reference to an officer who had once transported a pipe bomb back to the station house. I need to know more about why they, like, how somebody took a pipe bomb to the police station. Like, I need to know. I have so many questions about this circumstance because what the fuck? What the fuck? Yeah. Now, I mean, I don't actually have too much problem with them looking through the bag at this stage. Because, I mean, they could actually have reasonably thought that, I could actually have reasonably thought that this might be a, what do you call it? That maybe there might be something dangerous. And, that this is a situation where maybe there's a, maybe there's a circumstance where, what do you call it? I could see, but the thing is, a search at this stage to make sure there's nothing dangerous, is going to be pretty perfunctory, right? It's just, because at this stage, what you'd be looking for is like, is there a gun? Is there a bomb? Is there like a canister, like from The Rock with like the chains of like VX gas, right? Is there anything of those things, right? Because, I mean, you could actually be worried this guy might have pipe bombs to throw. But all you're going to be doing at that point is just being like, okay, is that all that we see, right? Is that everything? And, if you are seeing a, if you see like a gun, literally all you do at that point is you just go and like make sure it's unloaded, and then you'd put the gun back in the bag and take it back, just to be like, yes, okay, we know this isn't going to go off, when I throw it in the back seat and like shoot me in the leg or, whatever. Because no officer wants to get shot in the dick because they were handling somebody's backpack and it had a loose loaded gun with the safety off that just happens to run into whatever like sandwich factory this guy is also carrying, and like, a tube of jelly hits the trigger, right? Reasonable, right? Okay. Fox removed a red journal from the pouch and placed it on the table. Wasser recovered a waterproof bag, referred to as a Faraday bag, and removed a cell phone, a passport, and a wallet from inside the bag. Fox retrieved a small cardboard sleeve from the backpack and spent some time trying to open it with a knife. He eventually got it open and removed a computer data chip that was inside the cardboard. Interesting. Wasser handed the passport to Sergeant Miller and placed the other items in the bag. And while Hanley was speaking with the DA's office, the defendant asked McCoy why there were so many officers there, and McCoy replied they were just trying to figure it out. So, yeah. What is it? So, yeah. Wasser removed a pair of underwear from the backpack and unrolled it. Okay, that's interesting. Revealing a loaded magazine for a handgun. Is that a loaded magazine in your underwear, or are you happy to see me? I'm sure that they felt something in the underwear, and they were like, I need to know what is in the underwear. But yeah, I mean, of all the things they could have found rolled up in a pair of underwear, that is kind of the best thing there, right? So, yeah. Headaches. This is, at least it was there by itself. Yeah. Hopefully that load left a stain that came out with the detergent. Oh God. Yeah. Am I going to cover the 3-day Ebony Parker trial? Probably. I've been interesting on that one. But yeah. We did do Becky yet. We haven't done Chud yet. Chud is going to be last. So after announcing his discovery to the other officers, Trent stated, now that you've cleared it all, let's just go back to the station. Trent, promote this man. Trent has a brain in his skull. I like Trent. Trent's got a good head on his shoulders. Wasser responded that they were just making sure it's not a bomb or anything. You've seen it's not a bomb. So Fox told Wasser, now that we found it, the magazine, let's just take it back. Hanley testified that he then told Wasser and Fox that they should wait until they get back to the station before finishing the search of the backpack because he was concerned about cross-contamination of DNA evidence, and also because he did not want the search to occur in public. Everybody's telling Wasser and Fox to fuck off here. Because the last thing you want to do is go through this search and then later you do DNA testing and it comes back to Ronald fucking McDonald because you were laying all this stuff out on, on a table that rando people eat at. It's like, oh, look, we found DNA. It traces back to a chicken fucking McNugget. Like, come on. And now you've got the problem of, did a McNugget actually commit the murder? So, all right. Wasser and Fox then placed everything back inside the backpack, except for a few items, which were placed in a separate McDonald's bag to be taken back to the station. Stop and Shop has entered the discussion, folks. They're like, we're going to put this in a McDonald's bag. Can we have a solo cup? Can we maybe we'll just put this in like, a large pop cup or whatever. So, yeah. When asked if they had retrieved a particular item, Wasser stated that they had not completely searched the backpack because they just wanted to make sure there's no bombs. Trent then stated, at this point, you're probably going to need it to do a search warrant for it. Corporal Miller agreed. Sergeant Burns and Fox disagreed, stating that they were permitted to do a search incident to arrest. If there's any fucking disagreement, get the search warrant. I can tell you, as a defense lawyer, the thing that I hate most are the words search warrant. And the reason why I hate those words is because search warrant makes it really fucking difficult for me. I had a case with a guy who was found with, I think it was like $80,000 worth of cocaine. And this was discovered by emergency medical professionals, right? They were like EMTs, found it and were like, all right, we found this item and, and you know what the police did when they got there? They were like, don't look in the bag. We know there's a ton of cocaine, but don't look in the bag until we have the warrant. And they got a warrant, and then they looked in the bag and they found, look, it's full of fucking cocaine. That warrant made things so much more difficult because as a defense lawyer, I would have liked it a lot more if they had actually just gone in the bag and had a look-see. Because then I might have been able to exclude the cocaine and everybody's happy. Well, except the cops. My client would be happy, but, so, like, get the fucking warrant. Honestly, I might have asked for the warrant at the police, like, while they're still at the McDonald's. So, just sit there, separate the guy from the bag so that the two people are not there. And then you're just like, we need a warrant. We've identified this guy as Luigi Mangione. He's got a bag there. It is almost certainly containing relevant evidence. Can we get a warrant? And I'm pretty sure a judge would have been like, yep, warrant. Like, get the fucking warrant. If you are a police officer, get the fucking warrant. Like, this is, yeah. So Wasser carried the backpack to her patrol car to transport it to the station. I wouldn't have let Wasser in the same room as that backpack. While Fox carried the McDonald's bag of items to his car. McDonald's bag of items is like, you have got to be kidding me. Altoona Police Department inventory policies. Let's talk about inventory. Inventory is the complete most bullshit thing ever. And we'll talk about that. Several officers, including the evidence custodian, George Featherstone, testified about the policies and guidelines concerning inventory searches. And the relevant APD general orders were introduced into evidence. APD General Order 3.1.9A1 requires an inventory search of a detainee upon arrival at APD headquarters and before being placed in a cell. General Order 3.1.10A instructs how to properly document and store a detainee's property and requires officers to generate an itemized inventory of all items taken from the detainee. Any contraband, evidence, or weapons will not be returned to the detainee, no shit, but would be noted on the property form and documented in the official incident report. So, the thing here is that, what is it? So what they do is they say, that you have to, inventory everything. So what happens goes like this. Let's say I'm driving home, right? And I get pulled over because my car has an expired insurance, right? The insurance is out, and so I can't keep driving this car. So what they will do is they will go and they will say, we have to seize this car in order to get it off the road. By the way, this is why it's always best, if possible, to park your car somewhere it's legal to leave it. But so they go and they have your vehicle towed. Now, they do not have any grounds to search your vehicle for evidence, because at this point, there is nothing evidentiary related that, what are they going to find? Like a signed confession to not having any insurance? So there's nothing that they have to search for evidence for. But what they will do is they'll say, we need to do an inventory. And the inventory is they will search everything in the vehicle and say, we're doing this for an inventory. And this is a real source of frustration for me, because at least in my area, they have a fair number of circumstances where they're like, we did an inventory search. And you're like, okay, I want disclosure of the inventory. Show me what you found in the inventory. And they're like, we didn't write anything down. And I'm like, how the fuck is it an inventory if you didn't actually take an inventory? Because the idea behind an inventory search is this notion that you don't want somebody to come back and say, what happened to my Rolex and my Mona Lisa and, the 16 gold bars and $2 billion worth of Bitcoin that was on a thumb drive. And it's like, well, they're like, none of those things actually existed because of the, but so I asked them for an inventory and they're like, we didn't actually write anything down. And I'm like, well, then how the fuck was it an inventory? And you get the guy up on the stand. He's like, I did an inventory search. And I go, okay, cool. So what's the purpose of an inventory search, officer? And they're like, well, we need to document any valuables. We need to document any damage. We need to document any of these things. I say, cool. And so that's just to make sure that everybody gets everything back, right? Yes. And so that you can't be accused of taking somebody's, Rolex and their, 18-inch gold dildo, right? Yes. Okay, cool. So do you have an inventory that shows that my client didn't have a Rolex or an 18-inch gold dildo? And they're like, no, we didn't write anything down, but we totally would have written it down if we found an 18-inch gold dildo. That would have been we would have written that shit down. Okay, I believe that you probably would have taken note of that. Officer, how much is a spare tire worth? I don't know. You'd agree it's, worth a couple $100, right? Especially if it's on the rim, right? Yeah, okay. Was there a spare tire? Was there a spare tire in my client's car? And they go, I don't know. Well, you'd agree that a missing spare tire is exactly the kind of thing that, that somebody would, would be upset if it went missing, right? And they'd be like, well, yeah, okay, cool. Was there a jack? What do you mean? If you get a flat tire, did they have a jack? I don't know. Well, you'd agree that a lot of cars have a jack that comes with the car and fits into a very special little spot. That fits into a little cutout in the car, right? And somebody would be real upset if that was missing, right? Yeah, I guess. Was there one of those? I don't know. Was the guy's registration papers in there? And the cop is like, I don't know. So what fucking use is your inventory if you didn't write down any of this shit that you should be inventorying? Because, I mean, if I was an officer, I would be detailing. Are there, is there any visible damage? Is there a spare tire? Is there, like, what shit is there in the car, right? What is in the car? Because, like, right now, if you went and seized my Buick, which you'd have a hard time doing because it's, like, stuck in a fucking forest, but it is, that's another thing there, right? You would find, amongst other things, you would find a tire inflation kit. That tire inflation kit, is... I've got, like, a thing that plugs into the car and, runs off that. That costs money. I've got a can of Fix-A-Flat. That costs money, right? Like, all of these things cost money. It's still stuck. It is still stuck. It is good and stuck, right? Like, what does this have? What is in there? And Kyle Aiden Fox says, be right back, asking Barca if we can cast gold in the bad dragon forms. You should tell the bad dragon people to get off their butts and get me a referral code, because I will totally, use that referral code, because it'll be funny as fuck. And some people might buy some. Some people might want, like, yeah. All right. There are those people who have a fire extinguisher in their car and those who are one bad day away from their car burning to the ground. I should actually get a fire extinguisher for my car. I don't have that. So you're prepared for every possible scenario except getting stuck. I was prepared for getting stuck, just the shit to get unstuck didn't work. So, yeah. All right. So, when possible, detainees should be escorted to the APD station house intake area in order for the arrest to be processed. When possible, the detainee's property would be inventoried in his or her presence so as to minimize claims of theft or damage, i.e., you have a recording of all of this and say, hey, is there, like, you agree there's no Rolex here. Cool. All right. Every piece of clothing would be searched, as would every bag. Or, however, if the search revealed a weapon, the inventory search would be moved outside of the intake area and away from the detainee. Because, of course, you don't want the detainee grabbing a gun and popping somebody, right? So every piece of clothing would be searched, as would every bag. Jewelry, extra clothing, and other personal items would be removed and stored. During the intake process, the officers would determine which items were personal property to be returned and which items constituted contraband or evidence. Now, to me, I had some discussion with them by email, and they said that they don't have a referral code program yet, but that they were looking into it and they were going to let me know if they get one. But I really want them to... I want them to make that happen so that we can, yeah. So, what is it? Now, if it was up to me, the thing that they would do would be to, instead of, like, inventorying everything, they would just put everything into a sealed bag. Like, they should have garbage bag-sized evidence bags or garbage bag-sized bags that they're just like, all of your shit goes into the garbage bag and then it gets wrapped up and sealed and there you go, right? And nobody messed with it because you saw it all get sealed. But the cops don't want that, and they never want that. The reason why is because it doesn't let them dig through all of your shit. And so if they arrest somebody on, like, unpaid parking tickets, if you don't get to do an inventory search, you don't get to, like, you don't get to find their cocaine, for instance. So, all right. Personal property would be listed on a receipt and inventory form, then stored in a locker. Contraband or evidence would be documented, photographed, and placed in labeled evidence or labeled envelopes. So, what is it? Might actually buy something from Bad Dragon Chest because it was going to lose the fuck out of me to use your referral code. Yeah. A garbage bag size bag. I mean like a proper like evidence bag that is tamper evident and all of that. So, yeah. I saw somebody saying that would be a good way to turn, to be a big problem as to if you had like a tuna sandwich or something. Well, don't get arrested and yeah. All right. Does anyone think Becky was hired by the defense to do what she did? I'm on replay, but wanted to ask. No, defense would be crazy to do that. If defense was going to do anything, they'd hire Becky to push things the other way, because for defense, getting an acquittal is a good thing. Not the defense wouldn't be trying to push for a conviction. All right. Overhead cameras, as well as the officer's body-worn cameras, would record the searches of the detainee's person and property. APD officers were not required to write inventory lists simultaneously with the inventory search, but could document the items at a later time. All right. So the searches at the police station. However, we have hit the goal. And because we've hit the goal, I owe you guys the story of my detective fiction class. So I took a class on, I needed like one more credit to, for like graduation. I had it to a situation where it was just like any credit I needed. So I took a detective fiction class. DWR Murphy, I see what you're saying. We'll get there as soon as we can. I needed any credit. So I took this mystery and detective fiction class. And in that class, we started out with Murders at La Rue Morgue, which is like the first detective fiction story. It fucking sucks. But so every class that we took, everything that we talked about, because after that we moved on to like Sherlock Holmes, and every single time, Jules, May 30th, 6:00, Green Door Tavern. Every single time the class was like, what if these people are gay? And I was like, cool, but like Sherlock Holmes is not gay. Like canonically, that is just not a thing. Sherlock Holmes is not really interested in women, other than one woman that he meets and spends basically the rest of his life pining after. And Watson is pretty definitely not gay because Watson is married and faithful and like whatever. They were just good friends. And the thing that pisses me off is that by identifying every good friendship in the thing, they were like, all right, these people must be gay. It's like they were literally doing the gay panic thing. Like that's it. They were literally doing the gay panic thing. I see people saying buy a Ray shirt. There's no indication of any sexual interest in Watson or anyone else. It's like literally not a thing, right? So, but by being like every time these two guys spend too much time together, they must be gay, is literally just playing into homophobic notions, right? It's like, you can't have friendships because if you get too close, that's gay. And I'm like, fuck off. So anyway, I was annoyed every time they brought this up because it was like, there is nothing to this. You guys are just looking for this because you find it titillating. You find this to be like, ooh, wouldn't that be neat? But you're not actually reading the source material. You're just like inventing something because it gets your jollies off. And so then we got a substitute teacher, and the substitute teacher, and Raymond Chandler, they had Philip Marlowe must be gay because he turns down the women who are trying to manipulate him and gets into a wrestling match with somebody over trying to make sure that person doesn't shoot him. So they're like, that's gay. All right. So then we get this substitute teacher after I've already lost my cool with the original teacher there. And then they get this substitute teacher in, and we're talking about some other story, and she's like, guys, what if these characters are gay? And I was like, we have been through 6 fucking books or 6 fucking stories at this point, and every story, like, the analysis has been as deep as what if these two are gay? Is this the only fucking analysis you're capable of doing? Like, this is... God, I hated that so much, because it was just like everything was... Yeah. It's like, and there's no basis for it other than just like, this. And I'm thinking, I'm at a university. I'm paying good money for, like, people to ship random characters for, yeah. Nope. They were specifically saying this character, what if they're gay? And it's like, no. So, yeah, it was annoying. I had a rant about it. I ranted about it in class, and I was just like, what is that? Yeah. All right. Back to the case here. So, yeah, there are in fact old books with characters who are or implied to be gay. Why not talk about those? Which would have academic value and be interesting. I mean, absolutely. If you want to talk to me about Dorian Gray, we can talk about Dorian Gray, because Dorian Gray's got some hints that, he's got interest. There's other, things, but no. So, all right. The searches at the police station. Once the defendant was brought to the station, officers Fry and Austin Homan completed an intake, which involved obtaining the defendant's pedigree information, i.e. who he is, as well as searching the defendant's clothing. Fry collected the defendant's layers of clothing, his jewelry, which included a USB drive hanging on a necklace, and some personal items such as bus tickets. All right. The USB drive was set aside as evidence, while the personal items were collected in a Lowe's bag. I don't think those bus tickets are actually going to... I don't think those bus tickets are going to be useful to him. So, yeah. Meanwhile, Wasser arrived at the station carrying the backpack as well as the McDonald's bag, which had been handed to her by Fox. Wasser placed the backpack on a chair in the intake area where the defendant was being processed and placed the bag on the floor. She began looking through the backpack, opening a compartment that she had not searched at the McDonald's, and quickly found a handgun. Like, they searched the bag, and then they fail to find the fucking handgun. They can't find the peanut butter. Like, what is this police department? It is ridiculous how bad they are at searching things. After telling Deputy Chief Derek Swope about the gun, he had her move the backpack to another room to continue the search. Wasser took the backpack and bag to an adjoining hallway. As she cleared the gun, which is in scare quotes, she discovered it was loaded. She and Swope then placed it into an evidence box. They brought a loaded gun to the police station. Wasser continued to search the backpack, placing items in separate bags, including items that had been found at the McDonald's, such as the microchip, cell phone, and Faraday bag, the knife, and the loaded magazine, as well as items that had been found at the station, including a silencer, suppressor, folks. It's a suppressor. and a USB drive. At one point, she took the red notebook out of the backpack, examined it, and stated, "It's like a journal." When Swope asked if she should bag it, apparently suggesting it be treated as evidence rather than personal property, Wasser replied, "I would." Swope also stated at one point that Wasser should make sure there's no explosives in there. After removing the items and placing them in bags, Wasser asked if she should put all this back in, referring to personal items such as a bag of toiletries, batteries, clothing, and masks. An officer agreed that she should, and Wasser placed the items back in the backpack. Meanwhile, Lieutenant Hanley spoke with NYPD Detective Leonardi of the Manhattan South Homicide Squad. I mean, this thing is the most... this is like the most high-profile murder investigation at the country at this point. I would have put every goddamn thing into evidence bags because you don't know what's going to have like a blood trace or whatever else, right? So like you just don't know. And there's a footnote. All of the bagged evidence in envelopes as well as the personal property in the backpack was later transferred to Featherstone, the evidence custodian. Okay. So meanwhile, Lieutenant Hanley spoke with NYPD Detective Leonardi of the Manhattan South Homicide Squad, who stated that he was on his way to Altoona and asked that nobody speak with the defendant and requested that all of his property be held. Excellent. That is where things should be. Wasser returned to the intake area with the backpack, where it was then moved to Featherstone's office so there'd be more room to conduct an inventory search. Sergeant Eric Houston began photographing items recovered from the defendant, including a Maryland license, the fake New Jersey license, the wallet, passport, gun, and silencer suppressor. He also began photographing loose pieces of paper as well as some of the writings in the notebook. Houston and Hanley sent some photos of the evidence to detectives in New York. At some point, because this Featherstone's office became too crowded, the officers decided to move everything to the roll call room. Now they're moving. Okay, cool. Why is this such a shit show? In the roll call room, Burns photographed every item recovered from the defendant, including every loose piece of paper as well as every page in the notebook. We're just doing an inventory search, folks. And we're photographing every page of the notebook? That is not an inventory search. Burns was particularly careful to photograph where pages appeared to have been torn out of the notebook in order to protect against claims of tampering or damage. You know how else you can do that? You just put it directly into an evidence bag and you seal it. Featherstone packaged and labeled every item and kept a written record of each item recovered and photographed. So, application for a search warrant. Later that day, Houston prepared an application for a search warrant for all of the items recovered. I would have placed that application first, listing the items that had been recovered from the backpack and describing some of the information that had been found in the red notebook. Houston also added information about the shooting that had been obtained from Detective Oscar Diaz of the NYPD. Houston described the purpose of the warrant as to seize the items located during the search incident, to arrest and inventory the property, to continue the search of the items, and to maintain the property to later be transferred to the NYPD. Like, the NYPD would want everything about this, right? So, yeah. All right. The Blair County District Attorney's Office approved the warrant, and it was signed by a Pennsylvania judge. No shit, they approved it. Defendant statements. That evening, defendant was arraigned at the Blair County Courthouse on Pennsylvania charges on December 10th, while the defendant was housed at Pennsylvania's Huntington Correctional Institution. He was monitored by Corrections Officer Matthew Henry. Defendant told Henry that he was a software engineer, that he'd been arrested in McDonald's, that he'd been carrying a backpack, that the backpack contained a 3D printed pistol and a magazine, as well as a small amount of foreign currency, and that people were accusing him of being a foreign agent. Henry testified that the defendant blurted out these comments without any questioning from him. Now, I can kind of believe that because there was a police investigator that I thought was really, really effective. And the reason why I say that he was really effective is that he brought my client into an interview room and he sat the client down and he asked the client, do you want anything to eat? And the guy said, yeah, could I get like a McDonald's or whatever? And he said, sure. Well, like a Big Mac meal, will that do? And the guy's like, yeah, cool. And the guy says, oh, do you want to, ask me anything? And the officer said, look, I'm just here because I have to keep an eye on you, but you kind of disgust me. And if you could just keep your fucking mouth shut and don't talk to me, I'd really appreciate it. And my client, who was accused of like bad things with, things with children, was like, hey, and the officer's just like, could you shut the fuck up? I don't want to talk to you. You disgust me. And the guy's like, but I want to talk to you. And the officer's like, shut up. Stop. And so finally, this client is getting like upset by being told that this officer doesn't want to talk to him, and is like, and the officer's like, okay, look, fine. If you can't shut up, I will read you your rights. You can sign this thing, and then you can say whatever the hell you want. And he got a full confession out of my client. And all of it was by telling the guy to shut up. And it was really effective. So I could believe that he might have said things, because people want to talk. They want to say things, right? So on December 16th, defendant was being monitored by Officer Thomas Rivers. Defendant talked about his travels and places he'd seen in Vietnam and Thailand. He also talked about people appearing to be happier in third world countries despite living in poverty. And they also discussed the healthcare system. Why would you want to do that? Rivers could not recall who initiated the conversation, but Rivers did not get his opinion on private versus public healthcare systems. Defendant also asked Rivers how the media was portraying him and stated he'd heard he was being compared to Ted Kaczynski. Defendant also stated that he wanted to make a statement to the public. No, you don't, you moron. The next day, defendant spoke with Rivers about books, including discussing his favorite authors and recommending a book by Aldous Huxley. They also discussed the standard of health among Europeans compared to or Americans compared to Europeans. So, conclusions of law. Initially, this court must decide which state's law, New York or Pennsylvania's, applies to when determining whether evidence or statements should be suppressed. Jurisdiction's a big issue there. What is it? Defendant is being tried in New York for a crime that occurred in New York. Under these circumstances, it is clear that New York is the forum state and that New York has a paramount interest in the application of its law. So while the people argue that Pennsylvania law should apply as the Altoona Police Department followed Pennsylvania law in good faith, that is not the test under New York law, and in any event, New York does not have a good faith exception to the exclusionary rule. So, cool. The people also argue that the cases cited by the defense apply only where the defendant claimed violation of another state's search and seizure laws, because New York courts will not trouble themselves with asserted violations of other states' search and seizure law. People's Memorandum of Law at paragraph 51. This court does not believe, however, that those cases can be so limited. The courts clearly state that New York has a paramount interest in the application of its law, and that suppression issues, procedural issues, and evidentiary issues are governed by the law of the forum state. The courts do not limit this clear pronouncement, and therefore this court will follow New York law in deciding the issues involved. By the way, just to note, police officers have access to lawyers for legal advice. They have access to so if they have a situation where they can where if they're concerned, they can reach out. I have literally, here in my jurisdiction and in other jurisdictions, I have seen, we ran into a problem. We didn't know what to do with it. We ended up calling a lawyer. There is a town in Alberta that is halfway in Alberta and halfway in Saskatchewan. So it's also a town in Saskatchewan. I had a guy who got pulled over in Saskatchewan and drove about 30 feet into Alberta before he stopped because he got pulled over right at the border. And that disclosure noted that they took some time to contact legal counsel because they wanted to be absolutely sure that they were not fucking things up based on like the Alberta-Saskatchewan border thing. It didn't end up being an issue, but that was that was kind of a question that they had. So like, stop and ask. So search incident to arrest. Fourth Amendment protects individuals from unreasonable searches and seizures. New York Court of Appeals has interpreted our state constitution as providing even broader protection. So provision serves to shield citizens from warrantless intrusions, including of their personal effects. To justify a warrantless search, the people must meet two separate requirements. First, imposes spatial and temporal limitations to ensure that the search is not divorced in time or place from the arrest. And so you can't go search someone's house incident to arrest of them on the street. And to ensure that the search is not, or in the context of searching closed containers incident to arrest, the second requirement is that the people bear the burden of demonstrating the presence of exigent circumstances in order to invoke the exception to the warrant requirement. Exigent circumstances are, some sort of emergency, some sort of, instance where there's just a, where there's just a thing where it's just like, the plot of a lot of movies involves like exigent circumstances. So let's consider like the trademark or like, the prototypical example of exigent circumstances. Police get a report of a child that has been kidnapped off the street, right? Somebody, like a parent was walking their kid. Some guy comes out, grabs this kid off the street, chucks the kid into the back of an unmarked van, and then drives away, right? And so the police are looking for this, this vehicle, right? And it's really important because and they find the van, and it's parked out front of a house. And they can hear a kid screaming inside the house. This kid is screaming bloody murder. Well, the cops can probably kick down the door and go look for the kid, right? Because it's like, we don't have 20 minutes to wait for a warrant to go in because it sounds like the kid might be getting murdered now, like nowabouts, right? So that's like real exigent circumstances. Imagine Luigi Mangione said something like, they're sitting there, they've got the guy's backpack, and he says, in 5 minutes, it's not going to matter anyway because the bomb in my bag is going to go off. That would be exigent circumstances because now we're not in like we have time to go for a warrant. It's there might be a freaking bomb in there right now, right? So exigent circumstances is we got to do something right fucking now or else, things are going to be, going wrong, right? So in order to invoke the exigency exception, the property must be within the suspect's immediate control or grabbable area. Under those circumstances, there are two interests that justify a warrantless search: the safety of the public and the arresting officer, and the protection of evidence from destruction or concealment. So, like, if you've got a witness or a person who might be, like, able to swallow the cocaine or something, even a bag within the immediate control or grabbable area of the suspect at the time of his arrest may not be subject to a warrantless search incident to arrest unless the circumstance support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence located in the bag. Here, the backpack was not within the defendant's immediate control or grabbable area at the time of the arrest or search because they took it away from him, right? Hanley moved the backpack away from the defendant and out of his reach shortly after he arrived. While a number of officers stood around the defendant, Hanley considered him detained. A short while later, McCoy moved the backpack to a table about 9 feet away from the defendant, while officers continued to surround him. If Mangione had made a lunge for the bag to get the gun, he was going to get tackled by like 92 cops, right? So that was not going to be a thing. Once defendant was arrested for the false identification, he was handcuffed and remained surrounded by several officers. Hanley was not concerned that the defendant could reach the bag while rear cuffed. I mean, what's he going to do? Shoot somebody and, with his hands cuffed behind his back? Is he going to stick the gun in between his teeth and pull the trigger with his tongue? If so, then his popularity with women is well explained if he's got that capability. So McCoy was also unconcerned, testifying that the defendant was surrounded by officers who had good body positioning. The defendant was also cooperative, described by several officers as compliant and not combative, and offered no resistance to the frisk or the placing of the handcuffs. So, there we go. I accidentally skipped by. Under these circumstances, the backpack was not in the defendant's control or grabbable area. Indeed, the backpack was within the exclusive control of the police. So, carrying on. Even if the backpack could be seen as within the defendant's control or grabbable area, the people did not meet their burden of demonstrating exigency. The people assert that the police were merely searching for explosives in an effort to protect themselves and the public before removing the backpack to the station. However, what were the indications of explosives? So, however, this justification for searching the backpack does not hold up to scrutiny. The officers' actions were inconsistent with merely performing a safety search. The area where the police searched the backpack was open to the public and to employees, both of whom passed by the area on the way to their bathrooms, and in the case of employees, to gain access to the storage closets. If you think there's a bomb, why are you letting the employees walk by to use the shitter? Like, shitter plus bomb should not go, should not go together. So, a safety search for a possible bomb is inconsistent with this unsafe protocol. Moreover, the police stopped searching the backpack once they found the loaded magazine. Officer Fox even stated that now they'd found the magazine, let's just take it back. Similarly, if it was a search for a bomb, it was an incomplete one, as they left compartments unopened and untouched, including one with an entire fucking gun in it. Moreover, a search for explosives would be inconsistent with the examination of small items where a bomb would be unlikely to be found, such as the defendant's wallet. You're not really likely to put a bomb in a wallet. It doesn't fit. And the close examination of and opening of the cardboard sleeve. This court is unpersuaded that the people have met their burden of showing exigent circumstances. The people also argue that the search of the backpack was justified because the officers had a reasonable belief that the bag contained an operable gun. However, while the body-worn camera footage showed that officers did express concern at the scene that the backpack might contain a bomb, there was no evidence that a gun was a concern or that it was the basis for the search. But even if it were a legitimate concern, there was no possibility at the time of the search that the defendant might retrieve a gun from the backpack, and thus no exigency. Now, I could see circumstances where you might say, look, if the accused, or if there's a gun in there, you could have a real problem if the guy, even if the guy doesn't actually get a hold of it, because the guy could, the gun could go off, right? So, nor can it be that whenever a gun is alleged to have been used, that the police may conduct a warrantless search of a closed container without a reasonable belief that the safety of the officers is threatened, as that would run afoul of the Court of Appeals jurisprudence and would eviscerate the grabbable area doctrine. All right, so the case law basically precludes that argument. Cool. All right. Therefore, the evidence found during the search of the backpack at the McDonald's must be suppressed, including the magazine, cell phone, passport, wallet, and computer chip. Now, what do you note about all of these things? The magazine, cell phone, passport, wallet, and computer chip. Well, they they aren't the focus of the prosecution's case, right? They just aren't. I mean, the magazine is nice. The magazine is useful. But you know, I don't know what's on the computer chip, if there's anything interesting there. So yeah. What is that? Yeah, I mean, but I don't like his passport. His passport isn't going to be a big deal, right? Nobody's gonna care about the passport. Like, it just isn't a you know, it just isn't, right? So they've excluded a bunch of shit. They can say, look, we preserve these rights. But at the same time, it's like, who cares? This doesn't help Luigi in a big way. This is not the shit he needed excluded. So inventory searches at the station house. They note an inventory search is a search designed to properly catalog the contents of the item searched, and it must be conducted according to a familiar routine procedure. It must not be a ruse for general rummaging in order to discover incriminating evidence. Every single inventory search ever conducted anywhere ever in the history of time, every single inventory search, the whole practice of inventory searches writ large is a general ruse, or is a ruse for general rummaging in order to discover incriminating evidence. That is the real purpose of inventory searches. So when the court says, oh, it must not be a ruse, there is no other purpose. That is what they are for. They are for general rummaging to discover incriminating evidence. The courts basically have created this fiction that the police conduct inventory searches for any other purpose, and that is not really true. So, yeah. While the discovery of incriminating evidence may be a consequence of an inventory search, it should not be its purpose. It's always the purpose. That is why they do them. An inventory search procedure must be designed to protect the property of the defendant, protect the police against any claim of lost property, and protect police and others from dangerous instruments. Reasonable police regulations relating to inventory procedures administered in good faith satisfy the Fourth Amendment, and minor deviations from procedure will not invalidate an inventory search. Here it is clear that the Altoona Police Department had an established inventory search protocol that was set out in its written rules and regulations that met the three objectives and sufficiently limited the discretion of the searching officers. The people also demonstrated that the Altoona officers conducting the search properly and in compliance with established procedures. So, all right. So, what do we have? The red notebook will not be suppressed, as the officers did not open it or search it at the McDonald's. The red notebook is, I'm a defense lawyer. So the red notebook is the thing where they specifically found all of his stuff talking about like motive, about his grudges with the with the healthcare providers. So the red notebook is extremely damaging. And so that goes in. His passport means nothing. They're like, passport is out, but the red notebook is in. So they note this search sufficiently complied with Altoona procedure to be a valid inventory search, nor does the effort to separate evidence from personal property render the search unlawful. While Wasser did not prepare a written list of the items, APD policies did not require documentation to be simultaneous with the search, and all of the items were documented once they were moved to Featherstone's office and the larger area of the roll call room. So, yeah. And they say, and courts have upheld inventory searches where there was a delay in documentation, i.e., oh yes, insurance companies. Right, that's fair. Fair distinction. Yeah. Thus, it is clear that the Altoona Police Department had an established inventory search protocol, that the protocol was followed, and that the search produced the hallmark of an inventory search, a meaningful inventory list. All right. So, they get a warrant later. We're going to skip over that. His statements to law enforcement, his statements are not really the biggest deal there because they're not really the hugest thing. Let's talk about what they allow in. So things that are allowed in. They allow in the notebook where he talks about, here is all of my motivation. They allow in the suppressor. And they allow in the gun. So literally, they allow in the murder weapon. And yeah, yeah. Like, he's fucked. The gun and the notebook are enough that he is super, super fucked. And, like, there just isn't a, he doesn't have much of a case left. Honestly, his case is going to be a case of essentially what he needs at this point is jury nullification. He needs a jury to sit there and watch that shooting and be like, yeah, okay, that guy needed to be shot in the head. That's what he needs in order to get acquitted. And the thing is that he's got a better chance than your average bear of getting jury nullification, but I don't think it's going to be there for him. I think that at the end of the day, that he is going to spend the rest of his life in a cell, most likely, because people have this notion that jury nullification happens more often than it does. And the other thing is that they're probably going to exclude evidence of whether or not this particular guy is horrible, right? If this particular guy who got shot was awful, they're going to exclude all of that. And so what it's going to be is it's going to be a jury where they're told this guy has a grudge against health insurance executives and wants to kill a health insurance executive and kills one. And that's what they're going to get. So I see a lot of people on Twitter who are like, this is a great ruling for Mangione. Some people are upset at the judge for like excluding all of this. I mean, I think he's, I think he's, what do you call it? Yeah. I just, yeah. That's it. I just, I don't see this as a Turtle Boy win. I see this as a huge, loss. Like I don't see this as a Mangione win. I'm also checking Twitter. Twitter's turning into a thing. Twitter is also going off, so I'm checking that, and my brain crossed a wire here. I don't see this as a Mangione win. I see this as a Mangione, I see it as a huge loss. At the end of the day, he is, he's going to trial, and the gun's going in, the notebook's going in, and, yeah. After that, I think he's pretty much fucked. That's about it. So, all right. That, I think, wraps up that case. Let's cover Chud the Builder. So, if you don't know who Chud the Builder is, I didn't know who Chud the Builder is. Oh, wait, we should do super chats quickly. Not as many this time around, but we will do a swoop. MND and Vars's rant. We have, what does this button do? Thank you, Kyle. Runkle rant, thank you. Mary Swampy, new sub. I'm down for a rant. Welcome. Hi, Palm Mom, for the goal before I head to bed. Thank you. Against the Tide says, please like to help Ian reach his pro bono goals. Thank you. Catherine Lynn Fraser, looking forward to the new hot sauce release. I don't know when that'll be. I got to hassle my guy about that. BB Kings, the fact those accounts are trying hard to turn you on Turtle Boy should tell you everything you need to know. I'm allergic to drama, so honestly, what I'm kind of inclined to do is just mute every Turtle Boy related word. You know, mute Aiden, mute Kearney, mute, like, put a thing of just don't notify for like every word, and just keep it for a month, and just like let all of that just go into the ether, because I do not care for the drama. And again, I don't care whether, like, the whole point isn't whether Turtle Boy is a nice person or likable person or whatever. It's not even whether he's a good person. It's whether or not the rights issues are a big deal. And, you know, at the end of the day, like, I have fought for the rights of the public with, like, sex offenders and, like, you know, I literally represented a serial killer. Like, literally. And so, you know, when people are like, he's a terrible person, I'm like, cool. I get it. You hate the guy, but, like, that is where rights issues are fought, is with terrible people. And if we don't protect the rights of terrible people, like, you know, then we lose the rights for everybody, right? That's straight up, right? If you don't, because what ends up happening when the government wants to challenge a right or undermine a right or defeat a right, the government gets to shop for their, you know, the government gets to shop for, the worst possible person, right? So if they want to, like, find a search issue and push that they get to search more, right? They're not going to run this on, like, we searched the car of some grandma on her way to church and we found fucking nothing. They're not going to run that case. They're not going to run it on, we found, like, grandma had, like, you know, a lobster out of season or some shit, right? Like, they're going to run it based on, we searched this guy's car and we found, like, a child or, like, a dead woman or, you know, a bomb or, like, some shit like that. That's the case they're going to run it on. And if somebody doesn't fight it on the person who has a dead woman in their trunk, then it doesn't get fought, and that right evaporates. It's gone. It's gone for everybody. It's gone for me. It's gone for you. It's gone everybody. And so, like, you know, I fought a search issue for a guy who had 6 ounces of cocaine in his car. And if you don't know, 6 ounces of cocaine is a lot of coke. It is like, and there was never an issue about whether or not the guy had the cocaine, right? It was, everybody agreed the cocaine was in the car. The dude was driving the car. The only issue was the search done correctly? Was the search done properly? And so I fight that, not because I'm like, oh, my client is a super great dude and should totally be able to sell cocaine to whoever. That's not the issue. The issue is, like, fuck this guy, but, like, we gotta protect the rights. So, I mean, you can hate the shit out of the guy, but that doesn't... And I mean, you can legitimately, like, whatever. And I'm just so fucking tired of, like, the drama. So I'm just like, tempted to just be like, fuck all this for like a month. You guys can fight about this in, like, the ether, and I don't need to see it, and I don't need to pay attention to it, because it's not really about me either. Like, just that's about it. So it is a a side rant there. All right. A few more super chats. I'm at least 87% sure that most people talk about Mangione being hot are using Gen Z humor / memeing. It's a joke that gets around openly saying you low-key understand or agree with his actions. Fair. The Miss Monty, thank you so much. Gen X shenanigans, late getting here, tornadoes and thunderstorms. Stay safe. Honk Banana Nose, please say something to embarrass Tundi 2007 in front of their face-sitting dad. I saw that dad is now out of the thing, so yeah. All right, let's talk about... we're not covering the H3 Snarks thing in this video, or in this thing. But let's talk about Chud. Who's Chud? This dude is Chud. This is his mugshot. So, this is Chud. And why is he called Chud? Well, Chud is a term that is used online to refer to people who have anti-progressive views, right? So what this guy is saying is he is waving the flag of saying, I am a Chud. And yeah. So that is what he's doing. Now, what is Chud known for? Well, Chud is known for waving a big old NAMBLA flag and going up to parents as they come out of their schools and saying, hey, you know your kid? They're really sexy, and I think that the age of consent should be lowered so that I can sleep with your kid. None of that was true, by the way. Although he could actually have done all of that and kept the same mustache, and it would have been plausible, right? So the thing is that none of that is true, but legally, he is in exactly the same scenario, because what he actually does, what the actual thing is he actually goes up to black people, calls them the hard R N-word, and then, like, basically tries to provoke a reaction. The thing I'm saying, the reason why I did that little thought experiment is that there's a whole lot of people out there who are like, look, Chud can say whatever he wants. And the thing is that none of those people would be saying that Chud can say whatever he wants if whatever he wants was waving the NAMBLA flag. They say that he can say whatever he wants. Well, I say some of them would. But most of the people wouldn't if his free speech was waving the NAMBLA flag. Instead, what he does... No, not for real. It was very clear that was an illustration for humor value, right? It is instead what he's actually doing is he's going out and using the hard R N-word. So a lot of the people who are talking about, like, he's got the right to say whatever wouldn't actually hold that principle if it was there. But the other thing is that what this case is not, this case is not actually a free speech case. So what happens here is that Chud is leaving the courthouse on a he's leaving the courthouse on an unrelated matter, and he is confronted by a person who is annoyed by that. What is NAMBLA? NAMBLA was, I don't know if they still exist, North American Man Boy Love Association. NAMBLA promoted the idea of adult men sleeping with male children as a thing. They like it's awful, right? So the thing is that they were legal because they, whatever. So this guy goes out there, and this confrontation is unclear as to like what is going on, because Chud, although he's a live streamer, was not live streaming at this point. He was, he starts live streaming after the events. But a confrontation happens, and in the course of this confrontation, Chud shoots the guy who's confronting him, a black dude. And at the end of, and he also shoots his arm. He accidentally shoots his arm. So, so he ends up getting, like, both of them go to the hospital. The guy he shot is alive, which Chud should be really fucking grateful for, because, but the guy he shot is alive, and Chud went to the hospital to get his arm treated. He was fine. And then Chud gets arrested for attempted murder and some other shit. And the internet is going insane over this one, because they're like, this is a free speech issue. And some people are making this like Chud is, some sort of free speech martyr. And the thing is that this is not a free speech case. The First Amendment is not going to be relevant here, because the First Amendment would be relevant if the government was saying that Chud cannot say racist things. And the government isn't saying that. The government has not charged Chud for being a racist. The government has not charged Chud for saying the hard RN word. They haven't issued him an order saying that he has to stop saying those things. They haven't any of those things. What he is charged with is shooting a dude. And that is a different scenario. Now, Chud may have a self-defense case. Because what Chud's version of things is that he comes out of the courthouse, and that this dude comes up to him when Chud wasn't even live streaming, hadn't confronted him, hadn't anything, and that this dude comes up based on knowing who Chud is and is upset with this dude, and this guy starts swinging on Chud. And Chud says that he tries to back away, he tries to retreat, he tries to all of this stuff, and this guy just keeps trying to hit him, and that eventually Chud says he pulls his gun and shoots the guy, and that even after the guy was shot, the guy was continuing to try to hit him. That is Chud's version of events. On that version of events, Chud has a self-defense case. And so we can look at the applicable law. And so notwithstanding, whatever, a person who is not engaged in conduct that would constitute a felony or Class A misdemeanor and is in a place where the person has a right to be, has no duty to retreat before threatening or using force intended or likely to cause death or serious bodily injury if A, the person has a reasonable belief that there is an imminent threat of imminent danger of death, serious bodily injury, or grave sexual abuse. B, the danger creating the belief of imminent death, serious bodily injury, or grave sexual abuse is real. or honestly believed to be real at the time. So what does honestly believed to be real mean? Well, imagine that you are walking through the woods, right? And you see somebody with a rifle, and you see them shoot the rifle, and you believe that they're shooting at you. You honestly believe that they are shooting at you, right? You might be in a circumstance where you can defend yourself because you honestly believe that that person is shooting at you, even if it turns out that the person is shooting a deer that happens to be down the road, right? That is like a possibility, right? Let's imagine that somebody has been, let's imagine that like Bob sends me a message every day and he says, I'm going to kill you on, June 1st. I'm coming to your house and I'm going to kill you. And he starts sending me those messages now, May 18th. And he sends me another one May 19th. He sends me another one May 20th. He sends me one May 21st, May 22nd, May 23rd, May 24th. Every day he sends me a message saying, I'm going to kill you on, on June 1st. Right? And every single day he does that. June 1st, dude shows up at my door. And he doesn't just show up at my door. He shows up at my door and he's got a sword. He shows up and he's holding a sword. And he knocks on the door and I don't open the door. And he kicks down the door and he's got a sword and I shoot him in the dome. But somehow he lives, right? And what it turns out is that he changed his mind about killing me and he decided to bring the sword as an apology gift. He's like, sorry, I really feel bad about all the threatening to kill you. Here is a cool sword. Have the sword as an apology gift. Well, a court would absolutely believe it was reasonable and, for me to honestly believe that this guy was coming to kill me when he shows up at my door with a sword and kicks down the door and so forth, right? So, they don't need to find that the danger is real, just so long as I honestly believe it. And C, the belief of danger is founded upon reasonable grounds. So what this leaves is a whole lot of questions for a jury, right? Does he have a reasonable belief that he's in imminent danger of death, serious bodily injury, or grave sexual abuse? Note, death, serious bodily injury, not losing a tooth, not getting a lit, it's just, it's got to be actual serious bodily injury. So the jury might, for instance, determine that they might decide that he was not in danger of death. They might say he was in danger of getting punched and that that's not a danger of death. Now, the thing is that an unarmed person is not necessarily not a danger of death or serious bodily injury, because let's imagine you get punched in the face and you get knocked unconscious. Well, first of all, getting knocked unconscious is real bad for you. But second is the question of, what do they do after you're unconscious? Because you could, if I hit somebody and knock them out, I can just keep beating on the guy until they die. I could just stomp on their skull until it goes, and then, they're dead, right? So you can't necessarily say that an unarmed attack does not come with the risk of death or serious bodily injury, right? 100%. But that is an open question. What I suspect is that he checked his gun at the courthouse and then got it at the exit. So now there is another provision that we need to look at when we're looking at this. The threat or use of force against another is not justified. 1, if the person using force consented, that's not an issue here. 2, if the person using force provoked the other individual's use or attempted use of force, unless A, the person using force abandons the encounter or clearly communicates to the other the intent to do so, and B, the other person nevertheless continues or attempts to use unlawful force against the person. So, let's consider an example, right? Let's consider a hypothetical here. I go to the bar and I am feeling like getting into a fist fight at the bar. I want to get into a fight with somebody. And so I go up and I find the biggest, meanest dude with a bunch of prison tats. And, and I go up to this guy, I take my beer and I pour it in his lap. What's going to happen? Well, he's going to start punching me, right? And so I'm not allowed to use lethal force in that circumstance because I started the fight, right? I started the fight and so I provoked this. But I can regain my ability to use self-defense if I'm like, whoa, stop, and I'm clearly abandoning it. I'm attempting to retreat. I'm like holding up my hands. I'm whatever. And, then I might be able to regain the use of force. So the words that Chud might have used are not necessarily, like they might be provocation. But Chud says, I was retreating. I was not trying to, I was trying to. And so in those cases, he might be in a circumstance where he, where he's able to regain the use of force. These are the legal arguments, right? These are the arguments that you make when you are like in court in a legal scenario, right? These are the arguments that you make in a in like a law school hypothetical. Now, the problem with Chud, Chud's got a number of problems that make this a little difficult. Chud is fucking obnoxious. Everybody is going to hate Chud. There's a lot of people out there who are online who are like, look, Chud is a free speech advocate. And I'm going to tell you, the average member of a jury who gets pulled onto a jury, when they think about their freedom of speech, they are not super fussed about whether or not they have the right to go up to random black people and call them the hard RN word, right? For the average juror, this is actually something that is extremely bizarre and extremely offensive and like objectionable. So the average juror is not going to want or is not going to see this as like a cause célèbre, whereas a lot of people online are seeing this as like, Chud is a hero for like saying the things, because there's a lot of people who are just real weird out there. So, most of these people are not going to be sitting there going, Chud is a hero. What they're going to see is Chud was out there looking to pick fights. That is going to be what they're concluding out of all of this is he was out there looking to get into fights. And if they determine that he's out there looking to get into fights and to provoke a fight, then he might be in a lot of difficulty. In fact, jurors, to the extent that a juror is going to like engage in jury nullification, they're probably going to be nullifying in the direction of Chud gets convicted. Because the jury is going to want very, very badly to find a path towards Chud getting convicted. Chud also has some real bad tweets out there. And what I mean by that is that Chud has some tweets. One of them, and I can't find it right now. I was looking for it and I couldn't find it today. He said something along the lines of, and I apologize, what he said is really fucking offensive. He said, the series finale is when one of, and I'm paraphrasing here, he says something like, the series finale is when one of you monkeys chimps out and ends up dead on a sidewalk, and then you riot when I go free. And there is a very strong likelihood that that ends up in front of a jury. Very, very strong likelihood that that lands in front of a jury. Because if I'm the prosecution, my theory of the case is that Chud wanted a confrontation so that he could shoot somebody. And he wanted it for two reasons. Reason number one, and this is what I'd argue if I'm the prosecution, reason number one is because he's a racist sack of shit, right? That is going to be reason number one, is he is super racist. He wants to kill some black folks. And reason number two that I would be arguing if I'm the prosecution is that Chud knew that shooting somebody would get him money, would get him subscribers, would get him interest. And so he wanted to shoot somebody in order to become more famous and to earn money. And the thing is, those arguments are likely to make these issues relevant. And once they're relevant, at least some of his shit goes in front of a jury. And I think he's fucked, honestly, if that goes through. Because the jury's going to be like, okay, you say it's self-defense, but your tweets, dude, your tweets. And the other thing is they are almost certainly doing a search of his electronic devices. And whatever shit he says in public, I can guarantee you he probably says some even worse shit in his own private chats. Like the private chats where he discusses things is, you know, I think he's going to, and some of those things are going to go in. And here's the other thing. There's probably going to be some black folks on the jury. Like, straight up. And if I'm the prosecutor and Chud gets up to testify about his self-defense case, you know what I'm going to do? Chud. Mr. Chud. He's actually called Dalton Etherly, but I have in front of you a document. You know what that document is? Yeah, that's one of the tweets I sent. Okay. Can you read this jury or read that tweet to the, or read that to the jury? Read it. Read it now. And so Chud gets to drop the hard R in front of the group of jurors who are going to be sitting there fucking hating him. They're just going to be sitting there looking at him going, ooh, dude. Yep. It's going to be real bad. Really, really bad for the Chudster. And the thing is that, oh, that's actually a solid idea. Have a black prosecutor question him to really piss him off. There's a decent chance he gets a black judge. There's a decent chance, like, and what's he going to do? He's going to argue to the judge, I need you recused because I am a super racist and everyone knows I'm a super racist. And therefore I need you recused. Judge ain't going to go for it. Nope. I've seen people saying that they need to run this as a judge alone trial. I don't think so. I do not think a bench trial helps Chud in the slightest. Reason why is because if it goes to a bench trial, the judge is going to hear every bit of how much of a sack of shit this guy is. Because the same judge who hears the case will be the judge who hears all of the exclusion rulings. Will be the same judge who gets to go through every bit of racism or violence that this guy has ever articulated in his life. And as much as the judge will say, I can disabuse myself of that, it still affects the judge. Further, it looks like Tennessee has elected judges. And there is not going to be a judge on the planet that, like an elected judge who wants to be running for re-election on the basis of Chud getting acquitted. They just aren't, because their opposition is going to be running nonstop ads showing Chud racisming it up and being a nuisance streamer, and that election campaign writes itself. Like it does. Chud he's got a bond assigned at this point, and the bond that is assigned at this point is $1.25 million. It's over $1 million. And the reasons for that are A, he's made the news. B, Chud was already on bond when this happened. If you're already out on bond when you end up in a, when you end up facing a charge of attempt murder, it pushes your bond way the fuck up there. But also, what appears to have really pissed off the court was that this happened right outside the courthouse. If you really, really want to piss off a judge, do something at a courthouse. Now, Chud's got a GoFundMe. People set up a GoFundMe for Chud. And that GoFundMe raised the 10% necessary for his, for his bond in 2 days. So there is a motion by LA Bonding, and that's right here, the motion to make bond filed by LA Bonding. They filed that on May 15th at 11:20 a.m. And so this has been scheduled for a hearing on May 21st. Judge may or may not allow him out on bond at that time. And we'll see. It might actually be a give, send, go, but it's a fundraising thing, right? So we'll see. Chud may get out. And if Chud doesn't get out, he's in a really difficult spot because, quite frankly, it is a very, very rough spot. They've got him apparently isolated from other inmates, and that is probably because if he's not, he's going to die. He planned to defend himself if attacked. That's legal to do. It is legal to do so long as you are not fishing for attacks. Because if you plan to defend yourself if attacked, that's legal. Most people plan to defend themselves if attacked. But you can't plan to defend yourself if attacked and then go and get attacked, right? You can't go and like plan to get yourself attacked. Becca says his bond hearing is on the 26th. That is not what the court paperwork says. The court paperwork says his trial is scheduled for the 26th. His trial's not going to be running on the 26th, right? His trial is just, it's not. That's going to get continued. But his bond hearing is scheduled for the 21st. So, different things. Now, he didn't plan to get himself attacked. He was being stalked outside the courthouse. Well, let's talk about that, because one of the things that you know, the Chud supporters have been saying is you can't attack somebody just over words, right? You can't attack somebody just because they said some words. And the thing is you can watch a lot of those folks flipping real fast. So how is he able to post on X if he's locked up? Probably somebody else has access to his accounts. So let's look at that, because there is a this is the warrant for his arrest. And so the warrant for his arrest has a very different version of events. It says on May 13th, 2026, at approximately 13:19 hours, Dalton Etherly and Joshua Fox engaged in a verbal altercation in front of the Montgomery County Courthouse. During this verbal altercation, Mr. Etherly turned his body in a bladed stance towards Mr. Fox and reached for his firearm in his right jacket pocket. Thereafter, a physical altercation ensued. And so, if the arrest warrant, and the arrest warrants, they say that they got this off of like the cameras from the courthouse. If this is true, then the person who has the self-defense case isn't Chud. Because at that point, let's imagine that Joshua Fox comes up to this guy and says, "You're an asshole." And Chud pulls his gun, or Chud goes for his gun. Right? Chud goes and he's going to grab his gun because this guy is in his face, shouting at him, calling him an asshole, whatever else. Well, now the guy who's just using words is Joshua Fox, the victim, right? The guy who got shot, who may or may not be the victim. The complainant, we'll go with that, right? So Chud goes, and if Chud reaches for his gun, then we have a theoretical alternate case of the complainant here is defending himself because he goes up to call Chud an asshole, and Chud pulls a gun, and now the complainant is in fear for his safety. He's in fear, and so he goes and attacks Chud to prevent Chud from shooting him because he's worried Chud is going for his gun to shoot him. If this is what the video shows, that Chud pulls his gun or goes for his gun before the physical altercation, Chud's fucking done. He is sunk. He is like, somehow he has both sunk and caught fire. Because if that happens, what they have is Chud on video lying about the altercation, because Chud says, he hit me, he was hitting me, and then I pulled my gun because he was hitting me. Well, if the altercation shows Chud pulling his gun before he got hit, then that makes Chud a liar, and the jury will absolutely fucking convict him. 100%. They will convict him. So this video becomes real crucial. Real fucking crucial. Right? They say Mr. Etherly discharged his firearm, striking Mr. Fox multiple times. As a result of being shot, Mr. Fox was life-flighted to Vanderbilt Hospital and underwent emergency surgery. In addition, at the time shots were fired, there were several innocent bystanders in the area. Surveillance video of the incident shows a ricocheting projectile hitting nearby walls. So, yeah. I actually think Chud is in a real bad situation because the best version of events for Chud is Chud's version, where he says, this guy came up and just started hitting me. I went for the gun. And I shot him because the guy wouldn't stop hitting me. Okay. Jury could still convict him because the jury could say you did not have a reasonable belief that you were going to die or get serious injury. You only thought you were going to get punched in the face a couple of times, and that doesn't justify shooting a person, and therefore we're going to convict you. And partially this is really just because we fucking hate you because you're a horrible human. That is very much possible on Chud's version of events. On the arrest warrant version of events, Chud is sunk. He's done. He's cooked. But let's talk about, like, if Chud's version of events is true, we can talk about the difference between the law society or the law school fact pattern versus real practical stuff. Because, like, in law school, if I'm sitting there and I'm arguing this, I would say Chud's got a good defense on Chud's version of events, right? On Chud's version of events, notwithstanding the fact that he is a horrible, horrible person, like being a toxic whatever and being a nuisance streamer. On Chud's version of events, he has a decently arguable defense from the law school exam fact scenario pattern. It's not ironclad. It's not guaranteed. It's not a sure win by any stretch, but it's arguable, right? I would be like, if I gave this as a fact pattern on a law school exam and somebody said, I think Chud will be acquitted, I would not mark them as a 0, right? I would not be like, fuck y'all, 0. I would be like, walk me through the work and I'll give you the mark, right? Show me your work. But the real world is not a law school exam. In the real world, who you are matters. Like, I will tell you this right now. You go back to the Rittenhouse trial. You have a time machine. You put Kyle Rittenhouse up on the stand and he tells exactly the same story and the trial happens exactly the same way. But he testifies from the stand and he's got a swastika tattooed on his forehead. Rittenhouse, in that fact pattern, notwithstanding that legally not a single thing has changed, Rittenhouse is sitting in a cell right now waiting to die. Straight up, right? Like that is how that goes, right? And similarly, the people who got upset when I said, Chud, it goes around waving a NAMBLA flag and telling people that their kids are real sexy, because again, that was a hypothetical, not a thing he actually does. But like the people who got upset by that hypothetical are inherently noting that it matters who you are and whether you're likable. Because at the end of the day, legally speaking, the difference between Chud saying the hard RN word versus Chud saying, hey, your kid's real sexy, are legally exactly the same scenario, right? Legally speaking, they are the same facts. They're just like, you're saying things that will piss people off. You might have, the government can't say you can't say them, but yeah, these are extremely prejudicial things. And I note that's why judges exclude evidence that would prejudice the jury. The thing is that the test is whether it's more prejudicial than probative. You can get extremely prejudicial shit into a trial so long as it's also extremely probative, right? So let's consider an example of extremely prejudicial, information. Insanely prejudicial information. Bob has, as a hobby, Bob likes to just stomp kittens to death. That's what Bob does for fun. Stomps kittens. And he goes and he looks for the cutest possible kittens to stomp to death. Well, if Bob is charged with a murder that has nothing to do with the kitten stomping, that information probably never goes to the jury. It's like, it's unrelated. It sure is fucking gross and weird and horrible, and we hate Bob, and he should maybe be charged separately for all of that stuff, but the jury probably won't hear it. But we change the fact scenario just a wee bit. Wee little tweak to the facts. And so the tweak here is that Bob's buddy Fred discovers Bob's hobby of kitten stomping. And so now Bob's motive for shooting Fred is because of the horrible stuff that Bob does. At that point, all of that shit goes in. Because at that point, it is super relevant. Why does Bob shoot his buddy Fred, who he's known for years? Well, Bob shoots his buddy because Fred was about to expose him for doing the horrible prejudicial shit. That is how you get the prejudicial shit in, right? That is how you do it. And so if the prosecution's theory of the case is that Chud shot these guys because he's a racist, it is likely, not certain, that this evidence goes in. What is Chud's best case scenario? What is his best case for a trial? Chud's ideal fact scenario is not a judge alone trial. It's not a bench trial. Chud needs a jury. And what he needs is a jury who has no fucking idea who Chud is. They've never heard of Chud. They've never heard of a Chud. They don't know what a Chud means. They don't they just think Chud is kind of a funny word, or that maybe this guy had the nickname of Chud when he was growing up or whatever. And they need a judge to exclude the hell out of everything Chud does in his life, right? So they need a judge to exclude every bit of racism from Chud. They need a judge to exclude every bit of, all of that. So, yeah. Or they literally need they need a jury of like 12 rabidly racist people. That is the other possibility, right? The other possibility is just they need like the most, racist jury that they can possibly find. But even a racist jury is probably not going to like Chud. And you know why? Because even the racists are probably going to dislike him as a nuisance streamer. I have seen plenty of people online in various back corners of the internet saying, that they dislike black people, and that's not how they phrase it, but that they still think Chud sucks and they still hate Chud. Because nobody likes nuisance streamers. Like, everybody cheers for the nuisance streamers to go down. What's that guy, the like little weasel guy who has that like giant bodyguard who goes around picking fights with people? Doherty. Like, everybody cheers to see Doherty at some point. Everybody wants to see him get punched in the face or go to jail. Johnny Somali. You know how many people online were like, yes, we're super glad to see Johnny Somali go to jail for years. And it's not because they necessarily are like racist to Johnny Somali. They just really think he's a sack of shit, and he should go to jail because he's a sack of shit. Yeah, I mean, what is it? I don't know what a nuisance streamer is. So nuisance streamers are basically people who go about and their whole goal is to piss people off, to annoy people into reacting. And when they react, they film that. And so they do a whole lot of stuff where they film people who are reacting to them being jackasses. Any streamer that streams in public is a nuisance streamer. I don't know necessarily about that because I have seen people who stream in public who are not nuisance streamers. I've seen people who stream in public who are, there's some guy, I don't know what his like name is or whatever. I just saw him because I actually had the same notion that like everybody who streams in public is like a jackass. And this guy, his thing is that he goes and like does good in public, right? So he'll go out and like stream him like helping people and shit like that, right? So I mean, I've seen that kind of public streaming where somebody's like, they go out and they're like, all right, here's so there was one person who did public streaming, who was just like, going up to people and like helping them with their groceries and that kind of thing. So like that kind of thing is not really what I'd call nuisance streaming, right? That is, whatever. I've seen people streaming in public because they were doing stuff where they were doing like sword choreography in like a public park, and they were streaming it. And yeah, Runkle, didn't you stream in public for the Depp trial? I did, but I wasn't trying to stream the public. I was trying to stream, like I was in public spaces, but I was trying to stream just me, right? So like that kind of thing, right? Yeah, I mean, people that power wash driveways, you could go up to somebody and be like, hey, can I power wash your driveway? And then just stream that, right? The issue is the people that are recording didn't consent to being live streamed. You're not wrong. So yeah, I mean, I would draw a distinction between streaming in public and nuisance streaming, right? Those are like, those are different things, right? You get bike riders, for instance, who like stream themselves riding down a particular hill. And, there might be other people in public, but they're not actively trying to go out and be a piss off or whatever. They're just trying to be. But like folks like, Johnny Somali, Doherty, Chud, etc., their whole shtick is pissing off the public in order to, get these kinds of reactions, to get these kinds of, get these kind of results. that kind of stuff, right? Now, I will just say, if you want to deal with a nuisance streamer, if you have a nuisance streamer that is near you and you want to stop them from annoying you, your best weapon is your cell phone. And you know what your best weapon is to stop them? You pull out your cell phone and you start playing Disney, you start playing Metallica, and the stream goes down. Or, if you know who they are, like if you run into Jack Doherty in public and you know who he is, well, you pull up Jack Doherty's stream and you put it on. And I'll just show you what that'll be like. So I'm just going to go to YouTube. I'm just going to go to a little known channel, Runkle. And, oh, look, this guy is streaming. And so then you try to have a stream, and this is going on. And so then you try to have a stream, and this is going on. Is this going to be something that anybody's going to listen to? We're stopping that right now. I mean, at that point, you're not hitting them with the copyright hit. But, and it's not going to run in, it's not going to, but it's just going to annoy the shit out of every viewer. And the viewers are going to just like start fleeing. So you just sit there and you're just you just put on their own stream and I guarantee you they go away. So, they it would be a fun thing there. They now take out the music with AI edit in one button. They do that. I don't think they can do that if it's live streamed, but they also can't take out their own echo. And you know what? These live streamers, when they're sitting there, they're live streaming, they love to tell you what their channel is. You've got somebody who's there, you're like, hey man, what's your channel? And they're like, oh, I'm so-and-so. Cool. Playing your channel back to you. And they will leave. And it'll be it's very effective. So yeah. Right now the Chud the Chud case is very early on. And we'll see, because I expect we're going to see more court documents coming out. We're going to see more of these other things. And so I guess the other thing we should talk about is, what is Chud looking at if he is, if he's convicted? Well, Chud is in some trouble. Also, TX47, shoot me a message. I would love to talk to you about these experiences. So shoot me a message. So let's see what he's looking at. Well, the firearm charge that he's facing normally is 2 to 4 years. But because he triggers some enhancements, if convicted, he might be looking at a mandatory 6-year sentence at 100% service. And what that means is that he would do 6 years day for day. At least 6 years if he gets convicted on that count and the enhancements go in. The aggravated assault and reckless endangerment charges, 3 to 15 years. So 3 years to 15 years. And the big one, the attempted murder, the attempted criminal homicide, 15 to 60 years. So if Chud gets convicted, he could go way the fuck up there. And do you think a judge is going to sentence him at the low end of this scale or at the high end of the scale, given the racial comments he makes and given specifically, here's the thought the judges are going to have. The judge is going to think about whether or not the judge is going to think, I could have been walking out of that courthouse. I could have caught a bullet. A cop could have caught a bullet. A child victim of a serious criminal offense could have caught a bullet walking to and from that courthouse because he's shooting in public in a massive space, like in a space where there's a whole lot of people. And, you know, most people who are going to the courthouse aren't doing so because they want to. Most people who are going to the courthouse are doing so because they're compelled, right? They've got a subpoena, they've got a whatever. So I see lots of people online saying Chud is going to be fine. It's possible Chud gets acquitted, right? It is very possible. I can see a path to acquittal for Chud. But I see a lot more paths that lead to Chud spending a long time in a cell. Long time in a cell. And you know what? I am betting that if Chud ends up in a cell, if Chud ends up in a, if Chud ends up doing, what do you call it? If he ends up doing, say, 10 years, then I am betting that I'm betting that certain words drop out of his vocabulary because Chud will probably learn the hard way about the disproportionate incarceration rates of Black folks. And so if, there's going to be a lot of folks in there who will take, will take some serious, some serious umbrage with that. And the thing is that what this ends up meaning is that this ends up being very, very hard time for Chud if he ends up getting sentenced, because there's a few options. Option number one is that Chud gets put into protective custody or is held alone, and the psychological effects on somebody if they are held alone or in solitary are tremendous. Or he ends up in protective custody. If he's in protective custody, he's going to have other people around him. and he's going to have, he's going to have some other individuals around him, and whatever else. But who are those people going to be? Because when you're in protective custody, most of the people you'll be interacting with are sex offenders, specifically child sex offenders. Like that's who he'll be hanging around with. And I mean, I'm sure they'll appreciate the mustache, but yeah, it's rough. Or he goes into general population, and a lot of people, like, general population's rough. He may be subject to violence. And folks, I do not support sexual violence against people who suck. Like, I don't like the sexual violence jokes about people in custody, because typically that is aimed at the least violent offenders and the smallest and weakest offenders. So, all people make those jokes. The people that are the worst are the ones doing that, not the people who are targeted by it. So I don't that should not be something that is part of our system. It should not be part of the sentence. We're not doing that. But there is the real possibility of violence there. And there's also the possibility that to protect himself for violence, he Modeling Underdog says, stop messing with the stash, Runkle. Final warning. Fair. Oh, and I see the Snoopy with the stash. Fair enough. Although the Snoopy stash is glorious. But what is it? If he ends up having to pal around with, the hardcore racists in custody, the Aryans and whatever else, he's probably coming out with tattoos and probably coming out with, and I gotta say, if that's something he's rocking, it's going to be a lot harder for him to, have some sort of career or a streaming life or anything out there. Like, just straight up. So, yeah. Do you plan to do any coverage for the Laura Owens chase? Yes, I'm behind on it because I'm just so freaking busy these days. But I do plan to do some coverage on it, and I would like to catch up on it. Maybe I should try to bring somebody on to catch me up on it. But yeah, it's a big sort of thing there, because yeah. So yeah, it'll be interesting. But yeah, lots of people were like, Runkle, explain how he's going to be fine. He's not going to be fine. Like, he's in some real, real bad situation. But I think I'm going to wrap things up here. We're going to cover the last super chats. Matilda Heinen, hello from the Netherlands. Hello. I've never visited the Netherlands. I really want to. One day I will be in a position to do more travel, and that'll be something we'll do. I disagree with Runkle lots of times, but he always gets the actual law right. Props. And the thing is I sometimes get the law wrong. It is true. Sometimes I've gotten things wrong in, research or whatever. But, I try to correct myself when I've been wrong, and I try to listen to people. So you can't be always right, but you can be humble about it, right? So, and there's times when I'm like, I need to watch somebody else to get the law. I will say, what is it? Andrea Burkhart, I think, is the smartest person in LawTube. And straight up. So there are times that I've reached out to her to be like, tell me what's going on there. So Heaven Takes All Dogs, side rants are the best. I feel like to get into heaven, if you've got a dog, you've got to be vouched by your dog. So, just another ADHD witch. For those asking in the U.S., you can check your gun at the courthouse, and security takes you back and locks it up until you're ready to leave. That's not true of every courthouse, but some at least. We all need to know if there's footage from the courthouse or the folks from outside court. Someone's always filming something. The courthouse probably has a ton of surveillance cameras around it. So, yeah. Even if he comes up with the bond, doesn't he have to have collateral in that amount of 1.5 mil? That's up to the bail bondsman. And the bail bondsman may say, we want collateral, or they may say, we're fine just taking the 10%. If I was the bail bondsman, I would be like, you got to raise the full amount. But there might be a bail bonds company that is sympathetic to Chud. And so they might, for instance, say, we'll do it without collateral, just on the 10%, on the basis that we like you and we trust you. Now, the thing is that I don't think Chud, to my mind, is a good bail risk. Like, if you asked me to put up the bail money for him, I wouldn't. Because he is, he is up to some shit. And, he may be the kind of person who pushes the rules. And, it's something to consider, right? Glad to see this stream beat out lazing around. It is a long weekend for me. I thought about just like taking the day off and just, and then I was like, nah, we're going. We're going on that. Runkle, do you get the 10% back if you don't try to skip on bond? You do not get the 10% back at all. So the 10% is non-refundable. It is what the bail bondsmen are extending him the rest of the money because they get to keep the 10%. So like, let's say your bail is $1,000 and you have to put up $100 to get out. Well, the bail bondsman is putting up the $900 because they get to keep your $100, right? That's how that works. I should note, this arrangement of bail bondsman is illegal in Canada. It's a literal crime in Canada to take money to put up somebody's bail. There are no bail bondsmen here. So you have to put up the money yourself. Yeah. That tweet is a confession of intent, in my opinion. That's what the prosecution is going to argue. The defense is going to say, look, he just mouths off a lot online. It doesn't have to do with anything. He just talks, he just like talks shit. So that's certainly what I would be arguing if I was the defense is, look, this guy has a brand. He talks shit. None of this means anything. It's super prejudicial, but it's not very probative because, there's no way he knew that he was going to be confronted by this dude. Like, that's what I'd be arguing. And I don't know if it'll fly. The mattress shooting in Texas comes to mind. Lots of words. Yep. Words can absolutely be provocation. If you don't think words can be provocation, just imagine like you came up to somebody in public and you're like, hey man, I'm going to fuck your girlfriend. Do you think you're about to get into a fight? Yes, you are. Right? Like, that is absolutely a situation where you might be getting into a fight. You go, there's various words you can call people that will get you into a fight. Here in Canada, if I have somebody who I know has been to prison and I go up to them and I call them a punk doesn't sound like much, right? It sounds like one of those silly words. It doesn't sound all that bad, right? If I call somebody who has been to prison in Canada, or at least in my area of Canada, a punk, in front of their friends, in public, they are gonna go after me. They are gonna because that is a word that if you call somebody that in prison, here at least, they either will fight you or they will get the shit kicked out of them. Like, it is absolutely, it is absolutely a situation where, it's serious business. So Michigan Farm Boy got about 35 minutes behind, but it sounds like the New York court excluded all the stuff except means and motive. Yeah, they excluded all the stuff except the important bits. So, yeah. Salegamine, I don't know how I'm supposed to be pronouncing that. Thank you so much for the super sticker. Very generous. Rhett Mads, Runkle, can you pull his bond requirements from his previous case? I think it's $400. Why did he still have a gun if out on bond? He might not have been on no gun conditions because I don't see any charges of breaching his bond. So his previous thing that he's out on bond for was for walking out on like a $400 dinner. And if you walk out on a $400 dinner, you get charged, but it's not something where it's like, it doesn't involve a gun. And it doesn't involve violence. It doesn't involve any of that. So I could absolutely see them saying, yeah, it doesn't matter. We're not putting a no gun requirement. Love Trap podcast to catch up on Loa Owens. I just got to find the time. So yeah. All right. Goof is another one. If you call somebody a goof here in Canada, you're gonna get stabbed. And like you think, oh, goofy, it doesn't mean anything. You call someone a goof, in prison, like in Canada, what goof means is that you abuse children. And and if you don't fight somebody who calls you a goof, like if you're in custody, right, and somebody comes up to you and calls you a goof and you don't throw hands, it is considered basically like you accept it and you agree with it and you are okay with it. And, then you take on that status. So if somebody calls you a goof in custody, you have to go, right? It is like, this has got to be a thing. So, that is violence time, right? It just straight up. So, yeah. Even Canada's most inflammatory epithets are just fucking adorable. Canada can't be real. You would do better calling somebody like the hard R N-word in custody than you would calling them a goof. Like just straight up. What does punk mean? Punk basically is... I know this is going to be offensive, but punk basically is like effeminate homosexual or receiving homosexual is basically the what that means, and people fight over it in custody because it is. So all right, I know it's sort of an offensive thing, but like prison is not very progressive. So yeah. All right, let's wrap things up here, and I will see you guys soon. So good night all.